it is 9:01. It is a beautiful, if soggy, March day. If you are a school district that's been affected by the flooding, please know that, again, we're thinking about you. We're trying to think if there's anything we can do to be useful to you and support you. And if you are watching this live, God bless you. That means you put on your hip waders and got somewhere to watch it. I'm Karen Hasse. Steve Williams, Bobby Truey, and I make up KSP School Law, and we're going to spend this morning talking about the Student Discipline Act. We laugh because we have done this slideshow several times because it's so important to us that you understand the Student Discipline Act. And so we keep redoing it, thinking of new ways to talk to you about it, and we think we've done some new stuff with it today. But we love you all, but you still don't quite always get it. So I'm hoping that today's discussion will help us avoid some of the mistakes, issues, toe stepping that we've had involving student discipline issues with students. We have been working really hard to make these webinars good. I want to make sure they're good content as well as good ability for us to have interaction. And so this is Steve's cell phone number. You can text him questions anytime throughout the session today. We do have formal breaks built into the slides, but you can text those questions as they come to you, and we'll either answer them as we get them, or we'll save them up for the break, depending kind of on what the question is. So we crave your feedback. We're very happy to have you text us questions, and we would love to hear from you. Let's see. Oh, housekeeping wise, you should have all gotten a copy of the slides when Sherry sent out the link. We've fiddled with them slightly since then, but nothing that's too major. We also have on the website copies of all the forms, so there'll be links to all the forms you need to expel a kid, all the forms you need to long-term suspend a kid, all the forms you need to short-term suspend a kid. And we will leave those up indefinitely so that you can always go to our website on today's date and have the stuff that you need to do a student discipline matter with the confidence that you're using the right forms with the latest and greatest and most up-to-date stuff. Anything else now? Okay, we're going to start out by talking about some discipline issues that are developing because the unicameral has been very active, and well, Steve will tell you about what all they're doing.
Thank you. All right. Well, we thought we'd start off telling you a little bit about what might be changing as to what we're talking about today. We've got LB 515. I kind of call this a cleanup bill to the extent that one would exist for the Student Discipline Act. It's going to put in some timelines that don't currently exist, so we'll have to watch out for those. If students earn credits while they are out on suspension or expulsion and it's from an accredited school or program, you're going to have to accept those. Currently, you have to put in policy or when you expel somebody, let them know what your makeup policy is. That'll probably go away because now you're going to be required to let them make up homework and examinations. Currently, you get to select your own hearing officer. This bill would change that slightly. It would give the parents some input into who the hearing officer might be. And it also is going to require you to get employees to testify if parents or students want that to happen. We've got LB 165, the Too Young to Suspend bill. It's just like it sounds. You won't be allowed to suspend or expel early childhood or kindergarten students unless they cause serious bodily injury or if they're destroying property, or if a weapon is involved. We've got LB 147. This is the bill that Senator Groney has introduced. I think half of it we like, and I will say it doesn't go far enough, but my significant other is an assistant principal, and she takes the brunt of some of this abuse from students. The other half, we're not huge fans of, but the physical contact part, I like this. It kind of puts back into law something that was there, but that was taken out when the corporal punishment statutes were changed. But this allows you to use physical contact and restraint with violent students, the kids that they're beating us all up, and if they're having destructive behaviors or are destroying property. Interestingly, you can hold hands, you can hold their torso, you can hold their wrists, but you can't hold their legs, which I thought was interesting to me because that's the most damage that gets done to my significant other is when people kick her. So you can't tie them up, you can't use restraints, you can't use handcuffs. They specifically exclude that. it prohibits you from disciplining or from filing a lawsuit against a teacher as long as they've acted reasonably. And so that's the part. I actually wish they went further. In my perfect world, I call it the eye for an eye policy. Whatever the kid does to you, you should be allowed to do to them. It'll never be the law, but maybe someday. So this is a step in the right direction as far as I'm concerned. The other half, I'm not a huge fan of. I don't think any of us are. We call them snap suspensions. It essentially allows a teacher to exclude a kid out of the class, which we don't really love. We think that my fear on that part of it is it's going to allow weak teachers to simply kick kids out of class instead of learning how to do classroom discipline appropriately and have classroom management skills. So that part I'm not a huge fan of. But again, as long as they've acted reasonably, the administration can't do anything to that teacher in terms of discipline. And so we may get into a dispute as to whether a teacher has acted appropriately or not. We've got LB 390, and I should mention all of these bills are still in committee except for two, and the next one's one of them. LB 390, we've got the school resource officer bills. There's two of them. 390, Senator Pansy Brooks has made that her priority bill. She just did that yesterday or the day before. This bill is on general file. This one's going to require parents to receive notice anytime they have contact with an SRO. You're going to have a memorandum of understanding between law enforcement and the school district, which I don't have a problem with. The part I may not like, we'll have to see what happens, is NDE is going to be required to come up with kind of a form MOU. Depending on what that content is, we may or may not like it. We've drafted quite a few of these. I've drafted quite a few of these, and you can tailor them to your specific school district. You'll still be able to change them, but you can't put anything in that's inconsistent with the form from NDE. So that may or may not be a concern, again, depending on what the form turns out to be. You'll be required to enact some policies that you don't currently have. There'll be required training, 20 hours of training specific for school law enforcement, for the law enforcement officers and for school building administrators, at least one at each school building. You'll have to maintain some records, and then you have to put a complaint process in place as it relates to school resource officers. 589 is interesting. This is from Senator Chambers. And he essentially says law enforcement officers cannot be school resource officers, whether they're on duty or off duty. Okay, so let's go get somebody else. You still could. The problem is there's no corresponding change to the concealed carry statutes or weapons on school grounds statutes. Law enforcement officers basically are the only people who can carry weapons, firearms, on school grounds. And so if 5 school resource officers, they just couldn't be armed. So that's something to watch. There's a juuling bill, LB 149. Basically, that's going to criminalize the possession or use of any sort of vaping products for people who are under 21. And then finally, we've got LB 281, and this one's on general file, so it may move forward. Essentially, you have to post the toll-free child abuse hotline number on your wall somewhere in the school. So those are the changes that we have coming up. And I think Bobby is next.
Okay. Well, so one of the things that we always encourage, principals that call us with discipline questions to do, and I'm sure all of you sitting there are thinking, yeah, this is somewhere in my practice, is to think about at the front end of any sort of discipline issue, what sort of criminal and child abuse reporting obligations you may have. The problem in a lot of these cases that we see, and we see this actually playing out in some of the legislation this year, is that you are expected to understand every time there's been child abuse or some sort of violation of Nebraska criminal law. So we're going to cover these again just real briefly, but the key takeaway here is making sure that when you are kind of running through your checklist at the beginning of every discipline process, you don't leave this out. Now, we've got some bad examples that have hit the press recently. We've gotten calls in our office, frankly, from folks at newspapers that want to run stories about schools and their reporting policies. And so now is a really good time. I think never waste a good crisis. So now is a really good time to look at your child abuse and criminal reporting stuff, right? It's just because it's in the news, and now everybody that has read the World Herald understands there's a prosecution in Omaha that's happening against the principal up there. So now's again the time to make sure that you're not leaving one of these things off the table. Now that more members of the community, I think, are probably aware of these obligations. So the first thing we're going to talk about is child abuse and neglect. And the problem that we've had with some of the news coverage of this issue is it's sort of starting to read out the actual wording of the statute. So this is straight from 28.711, the statute that we have that talks about the obligations of everyone, right? We're all mandatory reporters, but also and specifically school employees and their responsibility to report child abuse and neglect. The red part of your slide, if you've got them printed in color, if not, it's italicized as well, says that anytime a school employee has reasonable cause to believe. So that is your standard, right? It's not every time we hear a report, we automatically turn around and make a call about child abuse. You've actually got to have reasonable cause to believe that either a child has been subjected to abuse or neglect, as those are defined, or you observe a child in circumstances which reasonably lead you to believe that the child could be subjected to abuse and neglect. And so there are two reporting obligations, but all of them, any reporting that you might have to do, is sort of premised by you first having reasonable cause to believe that it's happened, or that to the extent that it hasn't happened, it's reasonably likely that you've seen circumstances which will allow it to happen. So as you kind of read down the statute, you look and it tells you what you can do. So number one, you can always make a report to the child abuse hotline. I don't know that if I was a school administrator, that's the place that I'd go, just because I know they get a lot of reports depending on where you are geographically. Schools have varying levels of success calling the hotline and then getting those folks out promptly. But you can always definitely make a report to the appropriate local law enforcement officials. And so the reason that we typically say to report child abuse to law enforcement is because to the extent that it involves a student discipline issue, one child can abuse another, right? If you have a boyfriend and a girlfriend who are exchanging inappropriate pictures, if they're sexting each other, based on how widely all these definitions are written, that very well could be child abuse in addition to a crime. And so we always say call local law enforcement because that one call checks both boxes, right? Of both the child abuse reporting and then also this next section of violations of the criminal code. So not to recap all of the legislative changes from last year, but functionally, anybody that's been administering a building knows that this criminal law reporting obligation exists. And so 79-293 in our statutes talks about having to report any time that the principal believes that there has been, knows or suspects that there's been a violation of the Nebraska criminal code. The difference is that set of stuff that you had to report as of last year was tied directly to 79-267. So for those of you regular folks in the discipline statutes, you know 267 is the list of those things for which you can expel, long-term suspend, or mandatorily reassign. So if you know or suspect there's a violation of the criminal code, and it could also constitute grounds for school discipline, before the change in the statute last year, you just had to report all of that stuff. Part of the problem is that became circular because one of the grounds for discipline is a violation of a Nebraska criminal law. So you were reporting everything. Last year in the technical cleanup bill from the department, what they did is restructure this a little bit. This is where now you have to collaborate, much like you do for mandatory attendance, with your county attorney and figure out which of these crimes you're supposed to report. So you'll see the reference in 79-293 now says any of the things that are provided in subsection 79-262, which is the part that says you talk to your county attorney. So if last year you had to report it every time a kid threw a pencil at another one because that was an assault, maybe you talked to your county attorney who said, I don't want to hear about that stuff anymore. That did not used to absolve you of your reporting obligation until they changed this law. So the theory behind it is you can now work with your county attorney to report less criminal activity as long as you have agreed that that doesn't need to be reported. And so this is now the new statute in 79-262. That's where the reference to all those grounds for expulsion come back in. And it says, in collaboration with your county attorney. So on or before August 1st of each year, you have to have that discussion, similar to your mandatory attendance collaboration with the county attorney. We've heard mixed reviews on whether this has been successful and whether schools have actually gotten better guidance on what should be reported. I think several county attorneys have responded and said, let's just keep doing it how we've been doing it, which is okay. But just understand now that you do need even that clarity, right? If it's let's not change anything, you still have to get that, or at least try to get that sort of clarity by August 1 of each year. The last thing we talk about here is that we actually have exceptions or exemptions from any sort of liability to the extent you are the reporter. Right, so all of your teachers, for example, are also reporters. Any employee of the school is a child abuse reporter. Not everybody is a criminal code reporter. The statute says principals, but both of those reporting obligations come with exceptions. So unless you're reporting child abuse and you make a maliciously false statement, you are not going to be subject to any sort of liability for making a child abuse report. Similarly, in the criminal code, unless you pick up the phone and call law enforcement after a discipline incident occurs, and you know that the report is false, and that you should have known that when you were making it, it was false, right? So if you totally fabricate it, that's going to be a problem. But if basically you believe what you called in on, and you believed making your own credibility assessments that you called in a crime that was likely or that you believe occurred, there wouldn't be any liability for a principal making a criminal code report either. Okay, now any questions you have, and then we're going to move on. I think Steve's up next. So if you have questions, make sure to text those in, but we wanted to get those preliminaries covered first.
All right. As many of you know, I'm from Michigan. And so anytime I can blame Ohio for something, I do. And we can blame the entire Student Discipline Act on the state of Ohio. And that's because of Goss versus Lopez. We had some hooligans who started a food fight. And I'm envisioning John Belushi in Animal House going, food fight. So they start this big food fight. And so essentially the principal threw him out of school, didn't give him any process of any kind, just threw him out for 10 days or so. And he just had enough. And the court looked at that and said, well, you know, we generally don't get involved in school matters, but education is a fundamental right. So that was a big declaration. And so they said, if we're going to deal with a federal right, you have to give them some sort of due process rights. Interestingly enough, this was a 5-4 decision, very much along political lines. It was the liberals getting 5 and the conservatives getting 4. I'd be fascinated if this case was decided for the first time today to see how it would go, because that swing vote that we have often, I think it still might come out 5-4, but I'd be fascinated to see. But essentially, you have to give them basic due process rights, and that's notice of what the charge is, an explanation of your evidence, and a chance for them to tell their side of the story. That's really all it requires. If you're going to throw them out, according to Goss, if you're going to put them out of school for 10 days or more, you have to give them those rights. Our states took that down to 5 days, but we'll talk about that in a bit. So the Student Discipline Act, it's 40 statutes. We say this every time, read them. If I was a principal, I would want to have a good working knowledge of these 40 statutes. And quite frankly, you really could probably read 10 of them as a principal. A lot of them talk about the hearing process and appeals and things like that, that really, yeah, you might want to know it down the road, but in terms of actually applying it day to day, there's not that many statutes you have to read. But I think you should read those ones that apply to a principal and master those. But it covers anything that would put a kid outside of school. So suspensions, expulsions, the emergency exclusions, and mandatory reassignment to a different school. So the purpose of the SDA, I like to emphasize this just because I think this was put in place for people like me. I think Clarence Thomas and I are the only ones who think kids should be taken out behind the woodshed with a switch, and there's their due process. But and Clarence Thomas actually said that in one of the recent cases. But anyway, the purpose of the act is to protect kids from discipline. That's really what it is. It's to make sure that their rights are enforced. So it's to assure the protection of all students, their constitutional rights to due process and fundamental fairness. So it's making sure we're not doing what they did in Goss and just throwing them out without getting their side of the story and telling them the evidence. But again, it's within the context of an orderly and effective educational process. So even the legislatures and the courts acknowledge, hey, we still have to be able to run school. Their rights don't run over our rights. The sanctions defined in the act shall be interpreted at all times in light of the principles of free speech and assembly. So again, they're acknowledging student rights there, protected under the Constitution of both the United States and Nebraska, and in recognition of the right of every student to public education. You can see the focus is on let's keep them in school, right? And so we have to keep that in mind. That's the whole purpose of this entire act. So what kind of notice are they entitled to? They get any statement, notice, recommendation, determination. It has to be delivered either personally or by certified mail or registered mail. There is a statute in there that also talks about if they have actual knowledge, which comes in handy sometimes. Typically, you're going to give them in person everything in writing. But if they have actual knowledge, that's going to trump things, even if they didn't get something in writing. Discipline definitions, you should be very familiar with these. A short-term suspension as excluding kids from the schools for any period not to exceed 5 days. A long-term suspension is 6 through 19 days. We are not huge fans of those. We'll talk about that a little bit later. We've got expulsions, and that can vary depending on what the offense is. So it could be the remainder of the semester. It could be the remainder of the current semester and the next semester. It could be a calendar year, and that's for guns. And again, it depends on timing of the offense as well. If something occurs within that last 10 days at the end of a semester, that'll give you some additional time. A mandatory reassignment. This is the Karen Haase special. We'll let her give you her explanation of what it means. But here's what the statute says. It is the involuntary transfer of a student to another school in connection with any disciplinary action. Some people here may read that phrase right out of the definition, but Karen will defend herself here in a bit. An emergency exclusion basically means if they have a communicable disease, you can keep them out. The kids who are making death threats and stuff like that, they pose an imminent threat to others. That's the other time you would use emergency exclusion. We're going to talk a good deal about that and have an example on that one. Other authorized actions. There's a specific statute that says, well, in addition to throwing them out of school for whatever period of time, there's other things that you can do. You can take actions which are reasonably necessary, so you can't act willy-nilly. Is this supposed to be Karen's?
Yeah.
Oh, I'm
That
sorry.
never happens.
No, go ahead.
She steals from us.
This is
It's the other way.
fascinating.
Mark this down. This is the first time I've stolen a slide from Karen Haase. But anyway, which are reasonably necessary to aid the student to further school purposes or to prevent interference with the educational process. That comes right out of the statute, and we had a case that interpreted that. So I'm going to let Karen take over her slides now. No, I wouldn't want to steal your thunder.
So one of the things that I think we don't do enough of is think about our other options for student discipline other than suspension, expulsion, or mandatory reassignment. And this list is right out of the statute that tells us all the other things we can do with students short of kicking them out of school. One of the things that I like to do, and some of you have done it with me, is when we do like an expulsion agreement, which we'll explain here in a minute, we say we think your student would benefit from counseling, whether that's an alcohol assessment or therapeutic counseling. Be careful when you use this that you do not inadvertently say, oh, whoops, your kid is special ed and we should have identified him as emotionally disturbed or mentally ill before. But there are lots of situations where kids don't handle anxiety, don't handle stress well, don't handle anger well, don't have coping mechanisms that fall short of a disabling condition. And you can say, we want you to see, get a counselor on the outside. We want you to see the guidance counselor at lunch, that kind of thing. You have that ability. Parent conferences are easy. Rearrangement of schedules. You know what? You can't behave yourself when you're in class with Bobby because you can't leave him alone because you hate him. You're not allowed to be in chemistry anymore. You have that authority, and parents don't have a right really to do much about it. You can keep kids after school. That's lovely. We do have a few parents that say if the kid misses the bus, that's on us. That is not true. If it's part of our authorized actions under the Student Discipline Act, we absolutely can do that. And then you see the last two requirements that they receive therapeutic counseling and the psychological evaluation upon consent. Again, I'm a fan of those, but use them carefully so that you're not inadvertently admitting that we've committed some sort of child fine violation by not verifying the kid under the special education laws or Section 504. Daley is a fabulous case involving an allegation of corporal punishment. The teacher had worked for Bridgeport Public Schools for like 37 years, something crazy like that. He had a physical altercation with the kid, set the kid back down and kind of smacked him on the back of the head. The funny thing about Daley is this guy was actually not fired. This whole litigation was over administrative unpaid leave. And that went all the way up to the Nebraska Supreme Court. Daley and other cases are one of the reasons why I don't think we should do unpaid leave. I figure if we're going to have to go to the Supreme Court, we might as well get our money's worth and fire them. For those whoever's, well, never mind. I was going to make a snarky comment about the unicameral, but I won't. So in the middle of the Daley decision, there's a big discussion about what is corporal punishment and what isn't. And the Supreme Court said some of what Daley had done was corporal punishment. But the thing that we don't always talk about is they said some of what Daley did was not corporal punishment. And the court says that this other authorized action section that we just talked about, those things that were just bulleted on the last slide, gives authority to teachers and administrators to use physical contact short of corporal punishment to the degree necessary to preserve order and control in the school. So the kid that's like, hold on, dude, you can't touch me, or the parent who says, you are not allowed to put hands on my kid or I'll sue you, that's just not true. And Daly, and the Nebraska Supreme Court in Daly specifically says, teachers are allowed to do whatever is necessary short of corporal punishment in terms of physical contact to keep kids under control. My great aunt Eleanor was an elementary school teacher for years, and she was one of my idols growing up. And she was, for a while, she said that she'd been told by Lincoln Public Schools that she wasn't allowed to hug her littles anymore. And then Eleanor, because she was Eleanor, did it anyway. But you see right here, the teacher that says, I don't want to pat a kid on the back, I don't want to high five them, I don't want to give somebody that's fallen down on the playground a hug, you are allowed to have incidental physical contact as necessary to promote personal interaction. So I just think sometimes we get a little, don't smack kids, unless you're Steve, right? Don't commit corporal punishment. But Daly does give the authority to teachers and administrators to touch kids short of corporal punishment for a wide variety of other actions. So this brings us to the first question. While Steve reads the text, I was texting with somebody on Steve's phone about the view, and I should have done this at the beginning. If what you want to see is the slides on one side of your screen and us on the other, here's how you do that. Go up to the top of your screen where it says View Options, pull that down and select Gallery View. Then you'll have like the Hollywood Squares situation happening. Find our video in the Hollywood Squares, hover your mouse over that. Then in the upper right-hand corner, there'll be a little blue box. Click on that and select Spotlight Video. And then you should have a situation where you've got the slides and us side by side on the screen. And for those of you that haven't gotten that done or are like, well, crap, I don't know how to do that, we are recording this and we'll have the recording posted on the website. And that is the view that we will have on the recording. What do you?
I'm going to go back to the slide to talk about this question.
Oh, okay.
All right, we got a liability question. It says the scenario, female student reports a rape that occurred in the summer by a classmate. School gets law enforcement involved. They want to interview the student in the county it took place in, which is a 30-minute drive. Female student asks the school employee to drive her there because she cannot get there on her own. The male accused is found to be innocent ultimately, but parents are claiming they may sue the school because the school took the girl's side by driving her to the courthouse. Is the school at fault for trying to help the girl report this? Well, number one, as we know, they can sue you for anything. So don't be surprised if that happens. But here's our liability standard. You're reporting child abuse if she's of child abuse age, except for maliciously false statements. I don't see any maliciously false statement here, so I think you're clear under the child abuse statutes. So you can't be liable under those. The Nebraska Criminal Code, the report was false and the person making such report knew or should have known it was false. You didn't make a report. You simply brought the child in for the interview. So that's not even close. The report was made with negligent disregard for the truth or falsity of the report. Again, you didn't make a report. Even if you had made a report, I think you're safe under both of these. I think you're clear. I don't think, again, they could sue you, but I think your defense is going to get this case dismissed pretty quick.
I also will say this, as your lawyers, we wish people like this actually sued you, but they don't. Most of the time, they're just talking out their hat. So I do what's right for kids. You don't have to pretend like you don't believe a rape victim. In fact, I think you're statutorily obligated to report it and facilitate that.
I mean, you clearly had a reasonable belief that something occurred. You had no reason to disbelieve this student. I absolutely would report that.
We'll talk about Title IX as we go here too. So that is one of the things that you'd be factoring into that circumstance. Also, the ability to impose disciplinary consequences for even an off-campus sexual assault is triggered by the filing of a criminal complaint, not a conviction. So we'll talk about that as we go here. And if you attended our Title IX webinar, we talked about that quite a bit as well. But there are a lot of circumstances that have come up where there are criminal complaints filed. That's your trigger for discipline, even if it happened off school grounds. And I think in theory, even during the summer, right? So we'll look at the specific wording of that as we go. Real quick, we want to hit on, I'm not going to spend a ton of time on this, but there is a whole universe of things that you can use as a basis to keep order and impose discipline that is not contained in the Student Discipline Act. That whole universe is the board's authority to implement other rules as long as they're not inconsistent with the act. So for example, we'll talk about things like juuling, the possession of a jewel, right? Technically that doesn't have tobacco in it unless the student, you're able to test it and say, yep, that's tobacco in that, or not tobacco, but a nicotine alternative product in that jewel. One of the things that you can put in a board policy that outlines a rule of the school is not having the little device itself, right? I think you could put in a school rule something like, and a lot of you do have this stuff, you can't wear hats, right? That your student dress code is school board rules that if they're violated could lead to disciplinary consequences, assuming they're constitutional and lawful. So the board has a ton of authority, and your policies will have a lot of other rules in them. For example, you've got bullying, right? That's defined in 79267 as a basis that you can actually expel a student if they meet the definition of bullying. But there's no wording of harassment in there, right? Hazing is its own separate criminal law, but the word hazing is nowhere in the things in the statute that you can use to expel students. So a lot of the rules that the school board puts in place, it's the repeated violation of those, any of them, as long as they're lawful, that can also be grounds for student discipline up to expulsion. So if a student, you say to students, hey, you can't bring the little Juul device even if it's empty to school, they do that twice, you can expel them because that's a repeated violation of school rules. Those school rules, when we shorthand that, that is the board's authority to pass those. And so we've got statutes saying that, again, that the board can pass any of those that they want as long as they're not inconsistent with the act. And they can delegate to other school officials a responsibility to pass their own rules and to impose those or enforce those with respect to students. So for example, you could have a rule that says you have to have a hall pass to go to the bathroom, right? The board might not necessarily have that in its policy, but they can delegate to you as administrators the ability to control the hallway during passing periods. If a student doesn't have a hall pass, you could impose disciplinary consequences because that would be an example of authority delegated to the administrators in addition to those rules that are passed by the board. So this universe of stuff we use quite often, right? A couple of schools had circumstances this year where kids brought in look-alike guns. They brought in something that they didn't use it to make a terroristic threat. It was literally just a squirt gun or something that wasn't even a gun, or in one case, it was a cardboard cutout. There's nothing in the Student Discipline Act that says you can suspend or expel a student for having a cardboard cutout gun. If they engage in terroristic threats, if they menace kids with it, sure, now we've got a crime. But what if a kid just brings a little cardboard cutout and takes it out and shows other kids because they think it's funny? You can have a school rule that says you cannot have a look-alike gun. That's nowhere in the Student Discipline Act, but that would be a rule that the board could add to maintain order. So those are just a couple of examples. Any action taken by the board that violates the Student Discipline Act is null and void. So you cannot pass unreasonable or unlawful school rules and attempt to enforce those. An easy example would be all boys can wear the color blue, but no girls can. Unless you've got some sort of rational basis, that could be discrimination on the basis of sex. So that wouldn't be lawful. Any action that you took in support of that rule, because it would violate the Student Discipline Act and state and federal law, would be null and void. Here's why, if you are sitting there starting to kind of eyes gloss over at this point, snap back with me real quick. All of the technical requirements that we're going to talk about for the next 2.5 hours come back to this little phrase. When you call us and say, oh, I already sent the letter to the family, I just wanted you to look at it to make sure I did it right. If we see that you did not do it right, or there was a step that you missed, even if your letter looks great, that action is arguably null, void, and of no effect. So not complying with the material aspects of the Student Discipline Act, like the notice requirements, means that you cannot, you should not, if the parents file a lawsuit, they may very well win, to invalidate all the action that you took. So when we talk about things like, hey, call us ahead of time, call your school lawyer and ask how to do this right procedurally, make sure your forms are up to snuff, your processes are up to snuff. Don't just remember that's how you did it at your last school, because if that action is in material violation of any of the requirements of the act, it's null and void. So the board rules and standards, again, they can make their own rules as long as they're reasonably necessary to carry out or prevent interference with educational functions. We can tie that to about anything, right? The cardboard cutout of guns, that one's pretty easy. And I think it makes sense to have a school rule in that regard. And they must be clear and definite so as to provide clear notice to the student and parent. We see some schools struggle with this part because you write it in a way that is, well, we call balls and strikes. How do you know that that is this, that, or the other thing? Well, we know it when we see it. The person who is having the rule enforced against them must be able to look at that rule and have a clear understanding of how it applies to them.
Okay, sorry, I can't stop myself. When I talk digital citizenship to kids, I have been talking about a case where cheerleaders were flipping up their skirts and taking pictures of themselves. If I've been in your high school and talked about a butt selfie, that's what we're talking about. And it's an interesting exercise because the question is, do you have to say in your handbook, no butt selfies? And I don't think you have to be that specific. But do you have to say students may not take pictures of themselves when they're wearing school uniforms, when those pictures can, cause the school district to be regarded in a negative light? You're getting closer, right? But that wording in your handbooks matters a lot. And what we see is a lot of handbooks that are like an old ramshackle farmhouse that you've built on room after room and nobody's ever tightened them up. Having those written in a way that a lawyer cannot tug on a thread and get after you is money and time well spent. Even though I know this is the time of year where principals are like, God, I should look at the handbook, I don't have time. That is money and time well spent in the bank if you can get it right now so you're not paying us later to fight.
One of the things that I would add on to that is internal inconsistencies provide exactly that argument for the parents, right? If you've got an activity code of conduct that says something different about committing an assault compared to your student discipline, your general academic code of conduct, which rule applies, right? Which one is it that's prohibited? I suppose they could be different between an activity consequence and a discipline consequence, but everybody sitting out there knows chances are that's just because we have not actually sat down and made sure they're consistent. Internal inconsistencies are one of the easiest ways to give parent lawyers a chance to say that your rules were not clear and definite. So we've literally had lawsuits filed on that basis alone, is that it's not really clear which rule they're using to discipline the student. So these are the two things you got to keep in mind when you're writing those rules. And again, school officials other than board members can adapt these rules. The board can change its rules and standards, but those must be reposted. One of the questions we get all the time, hey, we want to add dueling to our handbook. We realized it wasn't in there. That's cool, but all of the distribution and notice stuff we just talked about, giving people notice that it's in there, has to then be redistributed. So if you're comfortable sending out a new link to a handbook and getting parent acknowledgement in the middle of the year, that's great. But to Karen's point, the time to really tackle this stuff is probably over the next few months before those handbooks go live again for 1920. The rules must be distributed to students and parents at the beginning of each year or at the time of enrollment. So you have an option enrollment student that comes in. Sometimes you're not thinking, oh, I better get their acknowledgement of the handbook. Add that to your intake processes. This is the one that if you write anything down, this is on the list of like Mount Rushmore things to make sure you get right. Your school rules, your student discipline policies, your activity policies, anything you call a code of conduct or a rule that you're going to enforce under the Discipline Act must be posted in conspicuous places in each school. So Steve reads the statutes. Karen and I read the statutes also, but a little more loosely. The fact of the matter is that the statute in this regard is clear, and there is no excuse not to have your student discipline rules and standards posted in conspicuous places, right? There's an S on that in the school. So again, rules can be changed, but even if you add dueling to the handbook mid-year, redistribute it to staff or to students and their families, get everybody's acknowledgement, kid brings a jewel into school, you say, ha, I added it this year, I got you now, buddy. But they go to the bulletin board and you haven't updated that copy. That again is a breach of a material provision of the law. You might not be able to discipline the kid. So make sure that you've got them posted in conspicuous places and that you've made reasonable efforts to redistribute those. I think a reasonable effort is replacing the one on the bulletin board because that's a pretty easy one to change. What?
Places.
Yeah, places, right.
Yeah.
Yes. So not one place, obviously. If you have it, for example, any different wing of the school, put it there. If you have a bulletin board for announcements, put it on both of those. But make sure that it's at least in more than one place. If we come out for a student discipline hearing, one of the calls we'll make before we come is, hey, just to be clear, I want to be able to have you walk me around to the places that is placed in the school. So make sure that you can do that. If you do that now when you go back to the district today, or if you're there, go out and check that that's happening.
I have to admit, I always find it amusing when we have to put it in conspicuous places. That was written by a lawyer or put in there because of a judge's decision. How many kids do you know that stand in the lunch period and just start flipping through your student discipline thing that's posted? But anyway, jurisdiction and authority. There are limits to what you can do based upon where these actions or students' actions occur. And a couple of questions you're going to want to ask is, did the incident occur on school grounds, in a school vehicle, or at a school activity? You're going to hear that repeatedly. We kind of steal second base a little bit. And part of this is because this act was put in place in 1976. Computers, especially laptops, weren't very prominent in 1976, as you may recall. Karen certainly does.
Hey.
So we read property to mean school grounds to be property. so that if they're using a school computer, iPad, whatever piece of material it might be or piece of equipment it might be, we consider that school grounds, unless and until we're told otherwise by a court. Clearly, that was the intent of the statute. It just didn't exist at the time. So that's how we read it. So you'll look here, location of offense. Look at that list: long-term suspension, expulsion, or mandatory reassignment. What is missing from there? Short-term suspension, emergency exclusion. So keep those in mind. So the location of the offense only applies to long-term suspension, expulsion, mandatory reassignment. Has to occur again on school grounds. This is right from the statute: school grounds, school vehicles, school-sponsored event or activity. So those are the locations of where it has occurred if you want to do one of those three disciplinary techniques. Where does this come from, or what do we do if it occurs off campus and it's causing problems on campus? We've got the Tinker case. We were lucky enough to see Mary Beth Tinker, and I believe that's her brother John. I'm not positive, but that's Mary Beth. We saw her. They were celebrating the 50th anniversary of this decision. And so we had a chance to see her speak, and she still goes around the country and appears and talks about this case and still advocates for student rights. But this was the black armband case back in 1969. The school became aware that they're planning to do this, so the principals adopted a policy saying, no armbands in school. That's not going to happen. So the kids showed up, the Tinker kids in particular showed up, wearing their armbands, and they get suspended. ACLU jumped in and sued, and the students ended up winning. And this is where we get our famous phrase that you're going to hear in all these presentations about student discipline. Students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. So what does that mean, though? They don't have unfettered ability to do whatever they want. And what do we do when something occurs off campus, but we're pretty sure it's going to cause a problem at school? Well, the court addressed that, and they said the school would have to prove facts which reasonably may have led school authorities to forecast substantial disruption or a material interference with school activities. It's kind of a delicate balancing test, and that's one where this is where we would want you to call if you're planning to use that piece, because it's tricky, very fact specific. Courts in one part of the country would rule one way, whereas courts in another part of the country would rule another way. So that I would agree with you if you're going, hey, what the heck does that mean? We can't give you a bright line rule. It's just impossible. But just keep in mind that the fact that something happened off campus doesn't mean your hands are completely tied. Okay, so even if the incident occurred outside of school grounds or outside of school vehicular activities, you get to ask the following questions. Did the incident cause you to reasonably forecast a material and substantial disruption of school functions? Especially think about the death threats. They find that I'm going to kill these people list at home. That's never been in school. It's never been discussed in school, but now it's out there. Is it reasonable to forecast that that's going to cause a disruption? Absolutely. Did the incident actually cause a material and substantial disruption of school functions? That, again, we would want to talk to you about the specific facts that you have. A lot of times the answer clearly is yes. Yes, they do. Did the incident reasonably cause another student to miss school functions or school activities? And I think you can add in there even a teacher, if a teacher has to miss because of, and we've had those cases where a student threatens their life in such a specific manner that they are freaked out and kind of have a meltdown and a breakdown. And so that's very real. So those are the things you need to consider. We're going to talk about what you can do in terms of short-term suspensions and emergency exclusions when those events occur.
All right, we're going to get into this hypothetical. We'll be looking at a break here in a second. All right, Karen, it's going to come.
Sorry. I just didn't want to forget. On posting of school rules, one of the questions that we kicked around yesterday was, can the conspicuous places be on your website? And the problem is when they wrote the statute, the interwebs did not exist. And so it's going to be hard for us to argue that the website is adequate. I think website can be one of the places that you communicate it, but I think you also should make a photocopy and put it on 2 bulletin boards. So that I just didn't want to forget to say that.
Yeah. I want to add one thing. Whenever I come and do an in-service for staff where I talk about things like your role as a teacher in helping both yourself and the school document these things like material and substantial disruption, judges love it if you can point to disruption of class time. Yes. And the problem that we see in documentation is exactly this one. So if you're going to go back and at the beginning of next year do some in-service training on documenting for your staff, Don't just write down, Steve had an outburst in class. Steve had an outburst in class, comma, and it took me 37 seconds before I was able to redirect Steve and get back to instruction. That 37 seconds to a judge is hugely important as compared to we had a disruption in class. That statement as a fact is great. It's probably objectively true that you had the disruption. What judges want to see is what disruption was that? What school function and process can we point to? And they love it if it's disruption of the actual education taking place in the classroom as compared to a redirection at a lunch table or at recess, right? They weigh these things based on your purpose of educating kids.
Cody and I were just doing witness interviews for a personnel hearing, and one of the issues was an email that the teacher had sent to all the students. And multiple teachers told us that kids were talking about it and whatever. But one of the witnesses said, it took me 13 minutes to get the kids refocused on the subject matter, and my class is only 47 minutes long. That was golden. And so, I mean, it's just that specific example made all the difference in the world in terms of us being confident we could establish disruption pursuant to the Tinker Standard.
Okay, we're going to talk first about extracurriculars. This is one of those in 79-258 that Karen was talking about earlier and Steve hit on, the list of other stuff you can do outside of what we consider traditional discipline. And we all know, the fact of the matter is when we come talk about digital citizenship in your schools, you ask students, you get a 5-day suspension or you get kicked off the basketball team, which of those hurts worse? You know the answer to that, right? And so we've got a lot of schools that know that their heaviest sort of artillery in these crazy cases, and some of them, is when you're looking at an extracurricular activity suspension. Another important thing to remember is, just like Steve talked about, the jurisdictional requirements of on school grounds in a school vehicle or at a school activity don't apply to extracurricular consequences. You want to expel a kid for getting in a fist fight at school, right? If you want to kick that kid out of class, you need to have that have occurred on school grounds in a school vehicle at a school activity. You want to say you have to miss 2 basketball games for a fist fight that occurred on the weekend, we think you can do that, right? As long as the student had reasonable notice that that was your activity consequence and that was one of the rules that the board put into effect. So this is a hypo that we're going to use to kind of talk through some of these issues. Mandy's a gen ed student on the basketball team. She goes to Colorado over Christmas break. We get this call fairly often whenever we have break times. It's spring break now, so next week we'll get some of these calls. She posts a selfie on Instagram, smoke them if you got them. Karen's parents believe that their kid should be starting over Mandy, which makes no sense. They bring the picture to the coach who says, oh, come on, it's legal in Colorado. I can't do anything about it. The student handbook says this: students may not unlawfully possess or use drugs during the school year. Coaches may have team rules in addition to these rules. So that's what the handbook says. I don't love that, right? Because students may not unlawfully possess or use drugs. I get why you might have that in there, but we'll talk about how that is of legal significance. Okay, so let's assume those are the facts. You're sitting there as the principal, the AD comes up to you and says, all right, how do we handle this? Number one, you can remove students from activities for almost any purpose. We'll talk about the cases we have in Nebraska here in a second, but functionally, the student's ability to participate in extracurriculars, we call a privilege. The cases in Nebraska talk about it's a little bit of a right. There's a right to some extent, but it's not necessarily the sort of right that we would be talking about in terms of, hey, you have to give them a whole bunch of due process. What we know is if your policy provides notice of what is considered prohibited conduct, you have defined where the policy applies, when students are expected to comply with it. And this is where we get into the question of, do you want to be 24/7, 365 so you can capture the drinking party in the weekend and in the summer? Or do you just want to be during your school day, or do you want to tie it closer to what happens actually at school, in a school vehicle, at school activities? The choice is yours, but what we know is that it has to be clear for the student so they understand when they would be governed by your activity code of conduct. And it must comply with the handbook and policies, even if a student was caught in the summer. So again, if you have handbooks and policies in place which allow you to look at something like while somebody like Mandy is on a break, or while a student does something like this in the summer, that's lawful as long as it's clear. We've got 3 cases from Nebraska that I'm going to talk about. The problem that we have in our state is our Nebraska Supreme Court, in our opinion, looked at the wrong case when it was trying to assess what right a student has to participate in extracurriculars. Braish v. DePasquale and French v. Cornwall, So if you're thinking to yourself, the French and Canadians are getting in a lot of trouble, they are, and it involves drinking, unsurprisingly. But in Brèche and in French, what you have is a group of students who essentially go to a weekend party in both cases. In the Brèche case, you've got a policy that says no drinking, no smoking at any point. Similarly in French, all of the kids in Brèche are on the basketball team. They are given a 2-week activity consequence. Hey, we heard you were drinking at a party over the weekend. That violates our student code of conduct in terms of extracurricular activities. You are given a 2-week break from the basketball team. In French, it was a wrestler and it was a 6-week break. So very similar facts for both of these cases. They get all the way to the Nebraska Supreme Court on this question of what rights do students have to participate in extracurriculars. In both Brèche and French, what they said is, it's a right to some extent. It's a very small right. But if you provide at least that minimum due process that you have to provide to students in other contexts, you meet with them, you ask them if they, what do you have to say for yourself? You get to make a credibility determination. Here's the evidence that I have. You move forward with the consequence. That in and of itself is sufficient to start an activity consequence. If we assume your handbook was clear and all the stuff we talked about before. So you can read the quotes from the court. A student's interest in participation in high school athletics is nevertheless a significant one. It's significant to the student, we agree. We're waiting for the right case eventually to go to the Nebraska Supreme Court and convince them that that sentence right there, it overstates what the law actually is. But the French case that says the same thing, basically. When you're talking about an activity consequence, it's somewhere short of the academic right to attend school, but north of basically for any reason whatsoever. So if your rules are clear, if you meet with a kid, say, hey, what do you want to do here? Give me your version of the facts. Here's the evidence that I have. You can typically move forward with an activity consequence. The Cave case we put up here, because this is the one that we're going to point to when we eventually get back to the Supreme Court on this issue. And what we're going to say is, this is a fascinating case to read. It's a federal case, right? So you have a baseball player who's kicked off of a baseball team for an activity consequence. They go to federal court and they say, hey, we've got a right to play baseball. Look at these cases from Nebraska that exist. We've got a right. Well, the difference between our state court and federal courts is the federal court, our 8th Circuit courts have a lot of cases that say, hey, you've got no right. We've got a case dating back to the 80s that involved the Missouri High School Activity Association. And the judges in those cases said students have absolutely no guaranteed right to participate in extracurriculars. So what we can tell you is we'd love you to be the test case. We don't really want you to be. And if you are following things like clear handbooks, at least giving the students the basic due process Steve talked about from Goss versus Lopez, you can move forward with an activity consequence. And if we get the chance, we'll argue to them that even if you didn't do it perfectly, it's okay because the student doesn't have any right. We'd rather you do it the right way and avoid the lawsuit, but that's kind of the state of affairs with activity consequences. So back to the question about Mandy and the dubage. Nice, Steve. Number one, investigate, right? You have to read. So as part of that, what we always say for investigations is sit down at the beginning before you just launch off and start asking questions and sketch yourself out even if it's just a short, it'll take you 30 seconds to put it together, a little outline of how you plan to investigate. Review your handbooks, review your coach's rules, review any rules that were given to the students in terms of this might apply, right? Because we looked at the statutes earlier that says you can delegate to folks like coaches to have their own team rules. And so if that has all happened lawfully, now you've got in your hands the list of stuff that you can't do. And so if you review those, you say, okay, we think Mandy may have violated the rule. You go talk to Mandy. You make sure, number one, that Mandy had notice of that. So had Mandy and her folks sign the activity handbook. Yep, absolutely got that done. Mandy, here's what I have heard. What do you have to say for yourself? What's your side of the story? Here's the evidence I have. You've got a screenshot of the Instagram post from Karen's parents. Give Mandy the choice to admit to it. Yep, I did. No, I didn't. That doesn't necessarily matter. What matters is the chance to talk to you about it. And then if you believe that it happened and Mandy violated the code of conduct, go ahead and impose your activity consequence. Anything to add to that? No. Break now or keep going?
Questions.
Oh, questions. Okay.
Is the next slide up? Okay. So we had a question texted in that Steve's going to read and I'm going to answer. And this is also while we sing and dance, your chance to text any other questions to Steve-O. And then after I answer this, we're going to take probably a 7-minute break, 10-minute break to give you a chance to check your email because you're totally not doing that while you're watching this webinar. Take any phone calls or whatever, and we'll get back to work. Okay.
All right. A student is being charged with assault against a classmate for an incident that took place at a community gym on a weekend. The student who was assaulted says he's nervous about school on Monday. What action or actions can or should the school take?
Well, question number one, is the person who is accused of the sex assault, has he or she been charged with
This
first?
is just assault. Just a straight
Just assault?
Yeah.
Oh, not sex assault.
Just a regular
A
assault.
regular assault.
We can see where you're headed.
Yeah, I was gonna say, well, that's what we've had this year is a ton of, if it was sex assault, you'd be able to expel. So this is a regular old assault off campus. The most you could do under the Student Discipline Act for exclusionary discipline is 5 days. I think the fact that the victim says he's fearful gives you that material and substantial disruption to get you to 5 days. If you believe that the aggressor is somebody that could, wail on this victim again, I think you could have the aggressor spend some time in in-school suspension as long as he or she is not special education. You could change the schedules of the aggressor or the victim. I probably would change the aggressor's schedule to have him not be around his victim.
No
Again,
contact.
assuming that it is not special education.
No contact directive.
You could give the aggressor a directive not to have any contact and not speak to the victim. And then if he violates that, now you have a violation of school rules that happens on campus that would give you a hook for a longer term suspension or expulsion.
Emergency exclusion.
I was just going to say, the last thing is you could try an emergency exclusion, because emergency exclusion says you can exclude a student if his presence at school is so disruptive that he threatens the educational rights of his peers. I don't love emergency exclusion in this context because how are things going to change over time? I suppose you could emergency exclude while you got some PTSD counseling for the victim and maybe some aggressive counseling for the aggressor. But emergency exclusion assumes that this is an emergent situation that someday is going to get better. And I don't know how this gets better with emergency exclusion, but I think that is an option you could consider. Anybody have anything to add from that?
We have another question. Would you accept via social media, et cetera, as proof of a violation? Absolutely.
Yeah.
That's often some of our best. Holding the Budweiser can. Hey, that's some of our best evidence that we've had, especially for these extracurriculars. So yes, absolutely use those.
The fear of photoshopping and altering the image is something that sometimes I hear back from people that ask this question. What if they somehow manipulated the image? That's why you need that Goss Against Lopez chance to talk with the kid that is accused of doing something wrong. Bobby, that's you wearing your football uniform. That is a Budweiser can in your hand. What do you have to say for yourself? Bobby's either going to say, it was a joke, or season was over, ha ha ha, in which case I'm going to box his ears and impose a discipline. Or Bobby can say, oh my God, I was holding a Pepsi can. And then you're going to be able to probably look at that image and do a little bit of sleuthing to see what you suspect, if that image was manipulated. And in the end, you as the administrator are entitled to make a credibility determination. If you believe Bobby, or if you know Bobby's a booze hound, those things matter in terms of you deciding who you believe.
Do not tie your hands with stupid provisions in
yes.
these handbooks.
Yes.
Don't say something like, as long as we don't get it all through hearsay. Number one, nobody sitting out there, and I'm including all of us in this room, really have any clue what the exact hearsay rules are.
Yep.
That's the first thing. Judges don't know them. Nobody knows them perfectly because it's designed to be this weird haphazard set of evidence rules that don't apply to you in the first place. Don't say that unless it's reported by an adult and not just a fellow student, you will not do anything.
Students who are observed by a staff member drinking or who self-report. Now all you've done is make it so that everybody keeps their goddamn mouth shut, which is, yes.
So make sure that you have nothing in those handbooks that limits your ability to make the credibility determination. The reason the Goss versus Lopez due process exists is for one of the reasons is a check against mistake.
Yep.
So if you've got something wrong in the evidence you have, if the kid wants to dispute it and say, that's why Karen's parents reported me, if I'm Mandy, is because they're mad that Karen's not getting to play and that's actually not marijuana, right? I mean, that's why you have that discussion. Don't put in there that it has to be an unlawful possession of marijuana, because you could say that we don't want kids on our basketball team smoking pot, even if it's legal someplace they go. That's an example. Don't have stuff in there that limits you. And if you haven't checked that recently, definitely check it.
Sometimes I look at handbooks and I think somebody wrote this that wanted to sound smart. And I think it's better to write handbooks and sound, I don't want to say sound dumb, but you should
clear.
write short declarative sentences, things that you can read and understand while a parent is yelling at you. That is the best kind of writing in a handbook. Okay, any other questions? All right, 10:01, we've been going for about an hour. If you're like me, you had a couple of cups of coffee before you sat down, so you may need to get rid of that coffee. We will come back and get back to work
10:10.
at 10:10 on the nose. So we're going to mute ourselves so you don't hear our crosstalk, but we will unmute and get back to work at 10:10.
Oh, wow, that didn't mean.
Because you did the slides, Steve.
Okay, we are unmuted. There is a little discussion here during the break about corporal punishment. I don't know that we explicitly say it in a slide, so let me say it out loud now and you can write it down. And again, when the unicameral then decides if they're gonna look at these slides and make comments, if you can have your handwritten notes that are accurate that say corporal punishment is prohibited in the state. You may not inflict pain for the purpose of punishing disfavored behavior. So with that said, it's 10:13. Hopefully you got any questions that you had answered. And I dropped this and I think I switched the battery. No, your computer's not forwarded. So we will go on to the next slide. This is me, right? Okay. So emergency exclusion, I got these slides because emergency exclusion has kind of become my jam. And I'll explain why here in a second. So here's the hypothetical. Sherry, a gen ed student, posts a picture with her boyfriend and the caption that says, "He's so hot." Karen replies, "He's fat and ugly and his mother dresses him funny." And that just makes Sherry crazy. So she says, "I'll see you tomorrow, biatch." So the question is, if we really think Sherry is a threat and Karen's parents are freaking out, calling the board and calling the superintendent, what do you do about this? The statutes do allow something called emergency exclusion. Now, everybody put down your pencils and look at me for just 1 second. Emergency exclusion, even though it's in the Student Discipline Act, it's not really discipline. I think about emergency exclusion as the situation where the student is so mentally ill that we don't think it's safe for her to be on campus. But we're going to lose this ability to do this. If we keep using emergency exclusion as discipline on the cheap, then the ACLU is going to get their hands on it and we're going to lose the ability to have this freedom. So if what you're saying is that Sherry in this situation is bad and she needs to be taught a lesson, I do not think emergency exclusion is the way to go. If you think that Sherry is violent and dangerous and that she's so mentally ill she does not know that she can't shoot someone in the head for making fun of her boyfriend, now we would have an emergency exclusion situation. But I don't want you thinking of it as discipline on the cheap. So here's the statute. You can emergency exclude a student if he or she has a dangerous communicable disease that's transmissible through normal school contacts and poses an imminent threat to the health and safety of the school community. HIV/AIDS was a huge dealio when Steve and I were coming up and just getting started as school lawyers. And the question was not whether or not they had a communicable disease, but whether it was transmissible through normal school contacts and whether that posed an imminent threat. What we have now, kids that have not been vaccinated with measles, mumps, and rubella, that kind of thing. The question is, does that pose an imminent threat? I don't think it does until you have an outbreak. And then you may need to send those kids home. So that's the first part of emergency exclusion. Then the second part, the one that we end up using more often, is if the student's conduct presents a clear threat to the physical safety of himself, herself, or others, or is so extremely disruptive as to make temporary removal necessary to preserve the rights of other students to pursue an education. Look there, temporary removal, right? This cannot be our game plan for the violent kindergartner that we don't know what to do. We can send him home for 5 days, and maybe we can extend it, but we still have to have the IEP team get together and make a game plan for what we're gonna do for this kid's placement on a permanent basis. It has to be temporary. And that word temporary is why, with the question that we had with the kid that had committed the assault off campus, why I don't think emergency exclusion is going to be a perfect answer for you there, because it has to be temporary. So if you're gonna leave the kid that did the wailing, leave him at home, the question is, what is it that's gonna change that would make it temporary, if that makes sense. So the way emergency exclusion works is initially the principal sends a letter to the family and says, this kid is out for 5 days, and you follow the same procedures as for short-term suspension. You do a little Goss against Lopez due process, you send a letter to mom and dad, wham, bam, thank you, ma'am, we are done, 5 days out. If you're going to extend that emergency exclusion beyond the 5 days, so we think Sherry's mentally ill. We say, the principal writes a letter that says, dear mom and dad, we believe that Sherry poses a threat to herself or members of the school community. And here's what I always say for these kind of cases. She cannot return to school until a licensed mental health practitioner tells us in writing that Sherry is not a threat to herself or to any member of the school community. Love, Mr. Principal, okay? If mom and dad take Sherry to a therapist tomorrow and the therapist says, no, she's fine, she gets to come back to school tomorrow, right? If the mom and dad take her to the therapist and the therapist says, I couldn't possibly certify in writing that Sherry is safe, now what we have is sort of a standoff where we say, well, she's welcome to come back as soon as we know that she's safe. Or if mom and dad say, we don't believe in no mental health practitioners because that stuff is voodoo witchcraft, which we've had happen. Now we're kind of in a standoff. If you believe, or if the therapist says, I can't even look at Sherry for 21 days, any of those circumstances, if you think the initial 5 days is going to last longer, after the 5th day, now the superintendent sends a letter that says we're going to extend it. Now you see the bullet point beyond 5 days, school board must adopt hearing procedure. Both our firm's policies, the Perry firm's policies, and the School Board Association policies have done a good job of just regurgitating the Student Discipline Act procedures right into the emergency exclusion policy. And all of them, I believe, say it can be extended with a letter from the superintendent. But notice that if the family does ask for a hearing, the final determination has to be made within 10 school days after the date of initial exclusion. The idea is that if the kid is unfairly being kept out, we should hurry up to get a decision made by some authority figure about whether or not this is appropriate. So here's a piece of homework for all of you. Go and check your policies. I think most of you listening, just as I looked over the registrant list, has either ours, Perry's, or the School Board Association policies, but go hunt up your board's policy on emergency exclusion and make sure that it includes these procedures and it has a process that you understand and can follow if you need to extend that emergency exclusion. I love this case. This is Gesse's case that he was defending Lincoln Public Schools, and it's everything old is new again, right? This is an inoculation case. These were students who had not been immunized for measles because mom and dad had religious objections to immunizations. And then there's a measles outbreak in Lincoln Public Schools. The parents said, you know, I think they were Christian Scientists, if I remember right, or I don't even know if the case says that. I might just know that from talking to people. But the parents were like, we believe that God will protect our children. So we will waive any liability of the school if our kids get measles. And then they sued saying, our kids have a constitutional right to attend school. You are discriminating against our kids based on our religious beliefs. That's an equal protection violation. Jim takes that all the way up to the Nebraska Supreme Court and wins it. The Nebraska Supreme Court says it is okay for the school to decide that it is unsafe for these girls to attend school when they have not been immunized and there's an active measles outbreak. And I like these two quotes from the Mack case. It is difficult to imagine, if not inconceivable, that the legislature would intend to shackle a school district's authority to prevent a dangerous and communicable disease from endangering unimmunized students and spreading through classrooms. I would highlight that and then just change the wording. It is difficult, if not inconceivable, to imagine that the legislature would intend to shackle a school district's authority to prevent a dangerous and violent student from endangering the community of schools with a threat of mass violence. I think we win that. Now we have to do it right? So don't be tossing kids willy-nilly, but if we do it under the right circumstances, I think the reasoning of Mack applies 100%. It is an unimmunized student's right to attend school on presentation of a properly signed immunization waiver. That is limited, however, by a board's authority to exclude the unimmunized student from school during the presence of a disease. And again, I think we can turn that around and say, it is a mentally ill student's right to attend school, but that is limited by the board's authority to keep other students safe if that mentally ill student poses an imminent threat of physical harm. So that's how we are reasoning with that. Again, every so often we get an unimmunized kid, but we use emergency exclusion much more for credible threats of violence than we do immunization. So back to Sherry. I would investigate to determine, is emergency exclusion necessary? Does she pose a clear threat to the physical safety, or is she extremely disruptive? Is this going to be a temporary removal, or is this more that Sherry's actions are volitional and therefore we should use traditional discipline to punish her, maybe a 5-day kick under short-term suspension? But she is entitled to due process of the lighter kind, right? You have to give her oral or written notice of charges. You have to explain to her how you know this. You have to have her give you a chance to give you her side of the story. And once you've done that little Gossett-Lopez due process, whether you're going to do emergency exclusion or short-term suspension, I think you've done what you have to do. If you're gonna do emergency exclusion with Sherry, you have to give written notice to the students and parents within 24 hours. You've got a short timeline since the exclusion itself is so short. I would describe the conduct and the rule or standard or the reason why that is unacceptable. And then I always try to put in there, here's what you have to do in order to return, because I think that checks that box for temporariness. If we say, if you do X, Y, and Z, then you can come back, we've established that it's temporary. And then you're supposed to make a reasonable effort to talk to the parents before the student returns to school to try to talk about what happened and how you can fix that going forward. If you want to extend Sherry to be out more than 5 days, if she won't go to a therapist or the family can't get into a therapist, the board has to have adopted that procedure for extending emergency exclusion that you're going to go look up. And then the superintendent sends the written notice of extension, which includes the ability for them to request a hearing. And then if they request a hearing, we have to hold the hearing within 10 days. Have you ever had an emergency exclusion hearing, Steve?
I have never had one.
I've never had one either. Have you? I have had disabled students, mentally ill students who we were serving pursuant to an IEP. I've had Disability Rights Nebraska get involved, but in that, I've had a couple of those where the therapist is like, oh my God, no, he's super dangerous. He can't come back to school. And so we've just extended out the emergency exclusion until we can figure out what we're gonna do with the kid. And Disability Rights Nebraska, in both of those cases, got involved and said, yeah, you're right. And so they didn't challenge it. So there's the end of emergency exclusion. I'm making these little sort of snarky comments. Let me just give you a little bit of the backstory. In front of the Education Committee yesterday, the NSEA put slides from our evaluation webinar in front of the committee saying that we hated teachers and we're trying to jack teachers around. And so I, like an idiot, busted over there and burst into the committee room and asked to be heard, and I'm not sure I did myself any good there. But anyway, here's the reason I'm saying that at this point. I do believe there are people out there that are looking to limit the ability of schools to exclude students from school. And the question we get from board members, probably my number one question right now, is what the hell are we gonna do with this violent third grader? Because everybody's gonna option out. And if we misuse emergency exclusion, if we don't get this right, we're gonna lose that safety valve. And I think that safety valve is crucially important. So I'm telling you, don't be emergency excluding Sherry if she's just a little hag that needs to be disciplined, right? Do the discipline process. But if Sherry is mentally ill and we are afraid that she does not have the ability to control herself and she has access to weapons, emergency exclusion is the way to go. But the Department of Ed, the special ed people have been told by some of our clients that Karen Hasse says anytime there's a violent SPED kid, just emergency exclude him. And that is not what I'm saying. I am saying when you have an imminent threat, this is our, the safety valve on the pressure cooker or the Instapot. But this is not your go-to for the violent special ed kid. We have to work the LRE continuum instead. So that's my little, I'll get off my soapbox now, but I'm really worried that especially if the stuff that we give you, which we're trying to do for continuing ed, becomes politicized, I'm nervous that I don't want to make our lives harder by doing this stuff. So, question, or you?
We have a question. Is providing each student with a school planner or handbook at the beginning of each year conspicuous enough, or do we still need to post student conduct rules around the school? You're going to have to post it in at least 2 places in each school. It says, the statute says in school.
Yeah.
So I think that is a very good practice.
If you have a planner on a hook, an extra one, maybe, but I think you have to post in addition to the planner.
What if the dangerous kid is not on an IEP yet?
Well, if the dangerous kid is not on an IEP yet, and you truly, again, this is a kid that you think is a school shooter threat, I would emergency exclude the kid. I would then start looking at, do we have data to support asking parents for consent to evaluate? I would get that request for consent to evaluate out to them. I've done this where we do, here's the emergency exclusion notice. Enclosed herein is also a request to evaluate. And if the kiddo is out for more than 10 days, we'll begin to provide some services so that we can do like manifestation, which we're going to talk about here in a second. But so I would do both of those things at the same time. My question is, if the kid is super violent and non-volitional and we haven't considered him for verification, I'm nervous now that we might have a child find violation that we're going to have to dance around. Okay, I'm done.
All right.
For now.
All right, let's talk a little bit about search and seizure. Bobby, being the tattletale he is, tells the principal that he saw Karen smoking before school. We know that would never happen. He said she put the cigarettes in her purse. Principal tracks down Karen and asks if he can look in her purse. Karen said, "Keep your blankety blank hands off my brand new Louis V bag that I totally got on sale," which is completely hypothetical. All right. Fourth Amendment. And so this is the pesky amendment that keeps us from doing whatever it is we want to do in terms of searches and seizures. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And again, the key words, unreasonable searches. And really the key word is unreasonable. You are allowed to do searches as long as they're reasonable. If you have reasonable suspicion to search, you are allowed to search. So let's talk about a few cases. The big one came out of the United States Supreme Court back in 1985. This was Miss O. I think her name is Miss Odom, if I remember right. In any event, a teacher or a principal found a couple of kids smoking in the bathroom, or there was smoke in the bathroom, brings the two girls into the principal's office, and the one just caved immediately. "Yes, I was smoking." Miss O, heck no, she was tough. She stayed strong. "Wasn't me. Don't know what you're talking about." And so the principal says, "Give me your purse. I'm going to search your purse." And so he did. And he found a smorgasbord of good stuff. He found cigarettes. He found weed. He found a list of people who owe me money. And then there was like 41 $1 bills. So she had the same second job that Bobby does. And so we have all this good stuff, right? And so they suspend her. This goes all the way. She challenges it and goes all the way up to the Supreme Court. And the court did a great job again of deferring to the schools. But they basically came up with the rule, if the search is reasonable at its inception, or if it's reasonable in scope, then it is a good search. You can do that. You'd have to have reasonable suspicion, and so in this case, the purse clearly could have contained the cigarettes that he was looking for, the papers, or whatever it is he wanted. So that was a legitimate search. It was reasonable at its inception. The stuff could have been in there, and it was reasonable in scope. As we say there, the number one thing to do is ask the student, "Hey, can I search this?" And if they say no, you call the parents and go, "Hey, this is what's happened. Can I search?" If they give consent, it's no longer a search. You're in great shape. You can look wherever you want as long as they give you consent. But if they refuse, that's when we go through these steps. We've got the JP versus Millard case. That was a fun one. That's not too old. And essentially, this goes to what is on school grounds. And in this case, Mr. JP parked right across the street, in the street. And during school, he ran out to the car. He got caught outside the building. He gave some explanation. The administration didn't quite believe it. And so they said, "Let's go to your car. We're going to search your car." And of course, they find drug paraphernalia, because that's what kids do when they leave the school, apparently. And so they suspend the kid. And again, a long-term suspension. We'll talk about that in a minute. And so he challenged that and said, "Hey, I wasn't on school grounds. Read those statutes. Read that Student Discipline Act. It says on school grounds, in a school vehicle, at a school activity. None of those three apply." And the Supreme Court completely 100% agreed and said, "Yeah, you're right. This was an illegitimate student discipline matter. You can't expel the kid. You can't long-term suspend him for that." And so they threw it out. And so that one made very clear, when they say on school grounds, they mean it. Then we've got the Riley case. This was actually a combination of two cases in the criminal context, but it is important for schools. This was about cell phones. This is the big cell phone case. And once upon a time, the biggest protection you could have was for your house. There's various levels of protections for looking at things. Obviously, if they're going to look in your bag, that's a little lower. If they're going to search your person, that's a little higher. If they want to come into your house, that's even higher. Essentially, the court put the cell phone on the same level as a house, if not even higher. They basically said, if you think about it, your entire life is on that phone. Everything about you. There's medical information. There's pictures. There's a million things on that phone, all about you, your credit card information. And so they said that's a pretty high standard to go in there. So the thing I would warn you there is, if you're ever wanting to look in a cell phone, call your attorney first, because we want to make sure you can do it. And I don't want to say you can't do it, because there are cases that said, yes, the search that was conducted was appropriate, but you have to make sure it's limited to certain search terms and certain search facts. So what is a search? It's any government conduct that intrudes into protected privacy interests, including looking into places not out in the open or otherwise exposed to public view. So if they are, not a search. This includes peeking, poking, prying into non-transparent containers such as lockers, desks, purse, backpacks, folders, books, and articles of clothing. And I would differentiate, if we own the lockers, that's different. If the locker is the possession of the kid, that's a different story. So if we own it, we put it in the handbook. We own the lockers, we're gonna search those whenever we want. That's legitimate. But you can see non-transparent containers. That's why a lot of people are going to the thing of, you wanna bring a backpack, that's fine. It's gotta be transparent because then you can see what's in it, and that's not a search, it's just plain view. Same thing with purses and those things. So something to keep in mind. Examples of searches: examining items or places that are not exposed to public view. So if you're touching a kid, if you're patting them down in any way just to see what's in that pocket, that's a search. Opening and inspecting personal items. Again, if they have a backpack, they have a purse, they have any kind of container, that's a search if you're looking at it. And so you would need to have reasonable suspicion before you can go in there and do that. Handling or feeling any closed item to determine its contents, kind of goes with the pat down. Using extraordinary means to enlarge a view of or to listen into closed or locked areas, containers, or possessions. This really comes from criminal cases where they're using heat-seeking devices to look into your house to see if you're in there. They were using these super duper telephoto lenses to look into the cracks in your curtains. That's a no-no. If they have a book or a journal or notes, again, you can't look at it unless you have reasonable suspicion. That's a personal item. It's not a search if it's viewable in plain sight. So let's take, you're out in the parking lot, you're walking through the parking lot, and you look in the back window of that pickup, there's a rifle, right? That's plain view. That's not a search. You can see it. If that was in a trunk of a car, different story. You can't see it if you're going in there. That's a search. The student authorized you to conduct the search. That's never a search, and that's our number one go-to is get consent. You'd be amazed at how many times they go, okay, knowing that there's stuff in there. And you examine an object after a student denies ownership of it. So if they ditch it and they go, hey, is that yours? Nope, not mine. That's free game, and you get to look at that.
What
Same
about
thing.
a journal that is on a school computer?
What about a journal that is on a school computer? That's a good one. I would say you could not search that. I don't think you could search the computer. I don't think you could open that file if you knew what it was. I suppose if you didn't know what it was, maybe that's a different question. But if you absolutely knew that it was a journal, you certainly could not go in there.
Just as an observer, Steve, I see Karen giving you a look that says she's about to disagree.
If your acceptable use policy says everything on the computer is subject to search.
Karen likes to play a little fast and loose. Again, some of us read cases and statutes, some of us don't. And so she reads them and then ignores them. But no, and that is an open issue. If you put into your acceptable use policy or into your handbook, hey, if it's on our computer, we can search it. That's the issue. My position, we own the computer in that hypothetical. And so it's similar to, again, you can see how the locker cases, it's very clear we own the locker, right? And we say we can look in there. Computer?
I actually agree with Steve. I think it's better to have it in your acceptable use policy, but if the file name on the Google Drive is super secret personal journal, we're gonna have to, I just think it's worth calling your lawyer. But like images that are saved, that it's obvious, that they've saved an image and you see it and it's on your Google Drive, I don't think that's a search. So, but that's the like cutting edge area of the law.
And when we're looking at the journal, I mean, it really depends. Hey, I saw last night at Karen's house, she had a hit list. It's in her journal in that computer file. Now I think you have reasonable suspicion to go in there. But if you're just looking around for something else, I don't think you just get to go in there willy-nilly. So let's see. If you can detect anything openly with any of your senses, if you can smell it, taste it, see it, hear it, that's all fair game. If you use extraordinary means to enhance perception in open areas. So again, we were saying using heat-seeking things or telephoto lenses to see into places inside of a house. If it's in the backyard, totally different scenario because it's out in the open. Was the search reasonable? And this again comes from TLO. You have to satisfy those two separate inquiries. Was it justified at its inception? So what facts did you possess that would make you want to look at that particular area or object? Was the scope of the search appropriate? So again, if we are looking for a rifle, you don't get to look in their pocket, right? We know it's not. But if you're looking for drugs and you've been told you have reasonable suspicion to believe they're in the pocket, I think you could do that. What was the one thing I wanted? Oh, strip searches. I wanted to address that because I don't think we put that. No, don't do it. Do not do it. We keep getting these news reports of schools doing strip searches. No, if you've reached that level that you think you need a strip search, call law enforcement. Do not put your ticket at risk. Do not put liability at risk. You're going to get sued and you're going to lose if you do a strip search. Don't do it. Okay, justified at the inception. Okay, so when is it justified at its inception? It's when there's a reasonable ground to suspect that it will reveal the violation of a law or school rule. So that's really the bottom line. Do we think we're going to find what we need to find to show that they broke a rule or broke the law? So that's when it's justified at its inception. We're going to let Bobby finish the hypo.
Okay, so you search Karen, right? You question Bobby's veracity. You aren't sure, you have reasonable suspicion. Karen refuses to give you permission to search. You call her mom, and Luann Hasse says, search that girl, you go ahead. And so you do, you search the purse, you find the cigarettes, you're now ready for consequences.
The funny thing is, all of those things could have happened.
Karen's not denying that this is not a hypothetical. Okay, so now what are you gonna do? You just sit there as principal superintendent, think, how would I process this one? Because this gets back to some of the stuff we talked about earlier. No doubt, Karen has cigarettes in her purse, and to the extent that she's got them in her purse, let's assume for our purposes here that Karen is not 18 years old, right? This gets to the juuling stuff. If Karen's not 18 years old, you can probably look and say possession of those is unlawful, and you're going to expel Karen, right? Now, for our purposes, let's assume Karen is 18 years old. So Karen is lawfully in possession of the cigarettes in terms of no criminal conduct, but she's violated a school rule. And that's the key distinction that we want to make here. If you go to 79-267 and you look at the reasons that you can expel a student from school, tobacco is not in there. It's nowhere to be found. You've got drugs, you've got alcohol, you've got alcoholic liquor, you don't have tobacco. So the problem that we run into with this juuling stuff and with an 18-year-old that possesses cigarettes or chew or whatever it might be, is what consequence can you impose? So if Karen is an 18-year-old, I think what you're looking at for her, probably, unless it's a repeated violation of school rules, is a short-term suspension. Even this gets back to one of the points we made earlier about having school rules that are different from violations of the law. You should have in your list of board-approved school rules any tobacco, any look-alike products, anything like that, to make sure that you're covered in the event somebody like Karen, if she's 18, is in possession of tobacco at school, because that is not an unlawful possession in terms of the criminal law. And so you've got to find another basis to impose discipline. And so we're going to talk briefly now about the short-term suspension stuff. We'll talk more about expulsion and all that as we go. But we're going to use this as a way to say, okay, this is how you would then be able to point to a school rule. A principal can deny a student the right to attend school or take part in any school function for a period of up to 5 days, as long as they can prove one of two things. Number one, this is conduct that constitutes grounds for expulsion in the Student Discipline Act. That would be whatever is in the list of 12, 13 things in 79-267. If you're a principal and don't have a copy of that at your desk, you should. Second thing, if you don't have a violation of 79-267, which you don't for tobacco, I'm not sure why we don't have tobacco in there. Maybe it's this 18-year-old thing, but it's not in there. But if you can point to any other violation of the board's or school officials' rules adopted under the Student Discipline Act, which could be in your student discipline policy, the list of those rules that you have that aren't otherwise articulated in the Act, it should be there. This is where we in our policies nest things like lookalikes, so that you can say, hey, even if it's not illegal, we've got a school rule on that basis. For a short-term suspension, the principal must investigate the alleged conduct or violation, which happened in Karen's case here. And if the principal determines that suspension is necessary to help any student further school purposes or prevent an interference with school purposes, they can go forward with it. However, before the suspension takes effect, finalizing that investigation with a discussion with Karen is important, because you have to provide the student who is to be suspended on a short-term basis oral or written notice of the charge against them, an explanation of the school's evidence. Hey, we talked to Bobby. Hey, I found these in your purse. What do you have to say for yourself? Oh, they're not mine. I was holding them for a friend, right? You can anticipate the excuses you'll get. But again, the important part is having that conversation so that Karen has an opportunity to deny, confirm, whatever it is she wants to do. Doesn't necessarily need to change your decision, but you got to give her that chance. Within 24 hours of completing this and making a decision that you're going to suspend Karen, or such additional time as is reasonably necessary. Now, we don't have a lot of gloss on that from the statutes. We always say, if you say to Karen at that point, go home, you're suspended for 3 days, I think that's entirely lawful, but you must, if you've done all the stuff we talked about in the previous 2 slides, but we say within 24 hours, get that letter home to Karen and her parents. I don't know what an additional time is reasonably necessary might be. Maybe if, for example, the school floods and you're now waiting 2 days because you can't get to your laptop, which is in the school. I think we could say that's probably a reasonably necessary delay, but you still got to get that letter to Karen and her folks. You have to, following the short-term suspension, send that written statement home describing the misconduct, the violation of the rules. Too often we see letters that just say things like, Karen is short-term suspended because she violated school rules, period. That's great, but you have to actually articulate the rule, which is why you got to know what's in your list of board adopted rules. And before Karen comes back to school, you have to make a reasonable effort to hold a conference with Karen and her parents before or at the time that they return. So we always put in our letters, and you'll see if you look at the forms we provided, the very last paragraph or one of the last ones in that short-term suspension letter says, I would like to meet with you on such and such a date, or I'll reach out to you to arrange a time to meet before the student returns to school. Short-term suspension is not limited to behavior that occurs on school grounds, at a school event, off school grounds, or in a school vehicle. So a short-term suspension, and this is where we get into this stuff about, well, what about a cyber bullying type of thing? If that misconduct, all of it happens outside of school time, you may still be able to use a short-term suspension or an activity suspension, because all of that stuff isn't covered by the jurisdictional limitations. There's no statutory appeal procedure in terms of the Student Discipline Act saying, if you give Karen a 3-day suspension for being 18 and having cigarettes, she gets to appeal to the superintendent, to the board, have a hearing. That stuff doesn't exist. But we see a lot of policies that add an appeal foolishly in those cases. And functionally, the student could file a lawsuit. They could use your general complaint procedure. So there are ways that we would articulate that you can check against some sort of impermissible short-term suspension, but there's nothing in the act that authorizes an appeal. Real quickly, we want to talk about the Walker case. This is a 7th grade student who was suspended for getting in a fist fight. And the parents, of course, this one's great, right? It's justified because it was in response to another kid taunting and provoking my daughter, and so therefore it was self-defense. We hear that all the time, in particular for cyberbullying, right? It's sort of like the old basketball cliche that, you know, he or she who commits the second foul is the one that gets caught. Typically true. The short fact of the matter is it's possible that both students could be subject to discipline. But the plaintiff in this case essentially says that you denied my kid due process rights because you did not basically follow up and do an appropriate investigation. You didn't handle this the right way. And so we point to this case to say, look at the judge's quote here. I think it's awesome. To contend, as the plaintiff does, that the plaintiff was denied due process under these facts and circumstances is utterly frivolous. A 3-day suspension from junior high can hardly be said to constitute such irreparable harm as to justify a judge getting in the middle of this, as long as they met the basic due process requirements of the short-term suspension statute. So that Goss versus Lopez stuff that happens, as long as you've done that, judges are not really want to step in and overturn those decisions, even if a parent does file a lawsuit. Okay, the school is required to, so this is part of the Student Discipline Act, right? The place that says you have to have a policy on makeup work. That's something that you must have and you must provide to the family if you're going to impose any sort of discipline, but in particular short-term suspension. Must provide the guidelines to students and the parent or guardian at the time of the suspension. So they cannot wait, right? You can't say, okay, 5 days later after your short-term suspension has been served, here's how you make up your work. It has to happen at the time you suspend them. So that should be in the letter that you send home to the family. Okay, any questions?
It's a fabulous question.
We do have some questions, but first I want to read the comment. This is from Corey Aldrich, and I think it's fantastic. You tell Bobby that officials do not miss the first foul and penalize the other. As a basketball official, my feelings are hurt. So that's number one. All right, Bobby, this one's for you. Does a student report constitute reasonable suspicion for a search?
It absolutely can. The fact of the matter is you are the educational expert. You get to decide, is that an unbelievable student, right? Somebody where you question whether or not they would be truthful. Do you know that these two students, the one who's reporting to you and the one who's alleged to have committed the misconduct, do they have a beef that predates this report? Is this person playing gotcha? Or is this an honor roll student who walks into your office with a completely flushed face because he or she has seen something that, you know, they've probably never seen before? You get to make the credibility determinations. This notion of we don't have probable cause, that's police stuff, right? We get to make determinations. You get to make determinations as school administrators. If you call us and say, hey, this student's report, is that enough? Our response is going to be, well, do you believe them? What are the facts and circumstances that you know about these two kids? So a single student report about another student can absolutely be a reasonable basis to go in and conduct a search if you believe them.
All right, Bobby, what if it's an in-school short-term suspension? Is it the same procedure as out of school, or is a call to the parent and documentation enough?
Call to the parent and documentation is enough. If it is an in-school suspension, right, we still think you should send a letter home saying this is what we're doing. But you can have, if what you're talking about is ISS for 3 days, you got special education implications, obviously, but is that what you're going to say? Okay. When Karen raises her hand, you just never know. But if you assume this is a general education student, you're going to give the gen ed student 3 days of ISS. If you have those circumstances, you don't owe them the same notice as you do for an out-of-school suspension. Again, the basis in the act is keeping kids in school. You get to modify schedules under 79-258. That's functionally what an ISS is, right? That's what a detention is. That's what makeup work is. That batch of other stuff you can do that isn't out-of-school discipline. That's why when Karen said we should look at some of these alternatives in these sticky, situations that you sometimes, I'm not really sure who to believe. What are we going to do? You're not depriving the student of the same type of right to do an ISS as an OSS.
These are great questions. Keep them coming. What consequence is appropriate if Karen is under 18?
If Karen is under 18 in possession of cigarettes, she's violated the Nebraska Criminal Code. If that happened on school grounds, in a school vehicle, at a school activity, you could expel Karen.
We'll talk about, so a lot of schools have some sort of rubric that says first offense tobaccos.
Yeah. So the legal question, if you called me cold and said, Bobby, we have a 16-year-old that was in possession of cigarettes or chew at school, what can we do? The short answer is you could expel him. Not because tobacco is listed, but because it's a violation of Nebraska criminal law, which is one of the bases that you can use to expel a student. Karen's right, though, that in all of these cases, because, and I get why you do this, you've got rubrics of consequences that you put in there so that you can suspend the board president's kid if that same sort of consequence is necessary compared to last week when you suspended that kid that everybody knows smokes every day, right? You put rubrics in place to make it objective what you have to do. I get why you do that. I'm telling you right now that we've seen plenty of those things come back to bite the administrators because functionally, I've seen one for your first criminal conviction, you get a 3-day out of school suspension. Your second criminal conviction, you might get an expulsion. Well, if kid number one commits murder, are you really going to say, that's great, no problem, we'll see you in 3 days? No, if they commit murder on school grounds, you're going to expel them. So why would you put something in? You can have consistent practices. You can have your own internal rubric that you're going to look at. And if you need to justify to that board president why you're going to suspend his kid for 3 days and make him miss 2 basketball games, it's because I did the same thing last week, Mr. Board President or Miss Board President. But putting a rubric in place just means now we got another place to look where you might have limited yourself.
You are on a roll and you're a common law expert. So cell phones are prohibited in classrooms. A cell phone can be seen in a student's pocket. What search protocol must be followed? What happens if the kid and the mom deny the request to empty the pocket?
So you're in class, you're a teacher, you know that everybody's got to put their cell phone in the little, you got the shoe holder on the back of the door, right? And everybody's got to put their cell phone in there on silent. But you see that Steve has his cell phone in his pocket. You can see the outline of a rectangle in there. I think what you'd first do is you'd walk up to Steve and you'd say, hey, I see your phone isn't over there in the holster. Is that your phone in your pocket? No. What is it? It's a calculator. Oh, well, can I see it? No. It looks an awful lot like a phone, Steve. Are you sure? Yeah, it's just my calculator, but you can't look in there. You could say to Steve, empty your pocket. And if Steve says, no, I'm not going to do it, I think you can still impose discipline. What do you reasonably believe? That's the question, right? If Steve's going to deny the ability to empty his pockets, you should not stick your hand in Steve's pocket. I would not do that. I don't care if the police tell you that's what you should
let's
do.
not be so quick.
Especially Steve's pocket. But that's, so I try not to get too hung. And here's another question we get all the time. If the purpose of the search is to confirm what you already know to be true, then why do it?
Right.
So if you know, because Steve brought you a screenshot from Bobby, that Bobby said, I'm going to beat you up after school, why do we need to search Steve's phone to confirm the exact same thing, right? If you don't need to search, don't do it. If you think that's a phone, impose the discipline you want, and they really can't challenge it as long as your determination is reasonable.
Is posting of the handbooks on the school website also considered a place? We discussed this very question last night. The problem we go back to in 1976, Internet didn't exist, right? Is that a place in school? Karen's position is we have computers in school, we have the internet in school, it's in school.
If you got a public computer in your library that's attached to the school, we're going to argue.
My position is why risk it, right? Let me put it this way. If that's what we had to deal with, I would make that argument. But why put yourself to have to make that argument when all you have to do is hang it up in 2 places? So,
Yeah.
but would I make that argument? I absolutely would. But the answer is unclear, and that's why would you take the risk? Can the post-prom committee, not associated with the school, search and breathalyze students before they board buses in our parking lot to attend the event? How liable is the school, even though it is not our event?
I'm so glad you asked Bobby this question. There
So-
you are.
That's
So-
Chip K. Great question.
Nicely done, Chip. We just put out a blog post Monday. I
She
don't.
was busy.
Yeah, no, I'm not blaming you, Chip. There's a blog post out there where we raise these very issues and say talk about them now. So good on you, Chip, for asking the question. Here's the first question you need to ask for all of these things. Do we owe special education accommodations? Can we breathalyze? All this stuff is really contingent on actually defining whose event it is, right? I don't believe that just saying, oh, don't worry, it's the junior parents that put on post-prom is sufficient. When they borrow equipment from the school, they use the school bus to transport the students to and from. There are staff members there that chaperone. If you cannot articulate exactly what I guess what we would need to see or what a judge would need to see to show it's not your event, then searching them carries what we call the imprimatur of the school, right? You would be conducting a Fourth Amendment event. Fourth Amendment doesn't apply to a private citizen. So if it's truly a private event and one of those junior parents says, all right, Steve, give me that liquor bottle in your pants, and Steve doesn't do it, then I think that's different than if that person is functionally acting as the school because it's really our event. So
Here's the
That's the
question
question.
to ask yourself. If I was dealing coke at post-prom, would you try to expel me? Because if it's truly not on school grounds, not at a school activity, not in a school vehicle, if I'm dealing coke, the most you can do to me is a 5-day kick because it's off school grounds. If you want to say, oh, no, anybody dealing drugs at post-prom, that's close enough to school that we want to be able to punish it, then own that. And then before you breathalyze the kid, I'm not saying you can't. I think you still can. I don't care what the ACLU says. I think it's still a volitional, like it's not school, it's an extracurricular activity. But I think we are kind of cheating when we want to punish misconduct at post-prom and then disclaim liability for post-prom all in the same breath.
it's the same stuff as your summer wrestling and basketball and football
Yes.
camps. It's all these same questions about how entangled is the school's involvement compared to the private activity, right? Do they use the school's uniforms? Do they take the school van? Do they have to rent it? If the church wanted to rent the school van to take a trip, they'd have to rent it. But the basketball coach, who's actually the basketball coach, just comes and grabs the keys and drives to the camp. All those interconnectedness questions, Chip, I think are the exact ones that you'd ask in this case. Let's put it this way. If it went in front of a judge, what they have to determine in terms of whether the school could be liable is whether there was state action. That's what the Fourth Amendment and all these constitutional analysis look at is, did the state act in a way that violated a right of a student? These are the questions they'd ask to decide if it was a school event or
So
not.
answer the question is, so let's say that post-prom is the junior parents, but it's really us. Can they breathalyze the kids before they get on the bus?
Post-prom is the junior parents. But really we concede that it's functionally a school event. They use the school bus. You can absolutely breathalyze the kids if you have a policy that makes it clear and they've gotten notice that you're going to do it, right? The ACLU has, in some cases, sent letters to schools that adopt mandatory random drug testing policies for activities, questioning whether or not a dance counts as an extracurricular. We think it does because the underlying basis for why you can drug test students that participate in extracurriculars, non-academic functions, is because they're diminished right in those. I don't think you've got any more right to be at prom than you do to play basketball, probably less, actually, because there's less of an educational component to prom than there is to the lessons you learn on the basketball court. For my official, there you go. I'll throw you one back. But the general notion of can you do it? Yes, absolutely. I think as long as you articulate it the right way and concede that when it is done by the junior parents, it's going to be done in a way that is compliant with the Fourth Amendment and our notice obligation.
All right, one more question. This one was for Karen. A student violates state law. Are we required to report it to legal authorities? If not, are some cases necessary to report?
So this is an interesting question. Brian Halstead, who is an attorney over at the Department of Ed, who I really like and I think is a good lawyer, he proposed in the department's technical cleanup bill last year a new provision in 79-262 that says we must confer with the county attorney every year and have the county attorney tell us which crimes he or she wants reported to them. And so if you're a policy service subscriber for KSB, you got a new policy, and then we had a little letter for you to send to the county attorney. And some county attorney said, I only want to know about it if it's sex or if there's bone showing, right? Some county attorney said, I want to know everything. If they spit on the sidewalk and, you know, commit an act of disturbing the peace, I want to know because those kids might be in the system for some other reason and I want that information. The vast majority of county attorneys just blew us off and didn't respond at all. And so 79262 also says that, not 262, 293 also says that we have to put into our handbook now the crimes which we will report to law enforcement. So if your county attorney said, I want everything reported, your handbook should say we will report all violations of the criminal code to the cops. If the county attorney says, I want to know if there's drugs, alcohol, or sex, then you would say that in your handbook. If the county attorney didn't say anything, then you get to decide for yourself what you're going to report. But so that's the source of this confusion about what you have to report and what you don't, because truly the law has been changed now to basically make it a school district by school district and county attorney by county attorney decision. And so stuff that they may be calling the cops for in Hitchcock County, they don't call the cops for in Dundee County, Stratton, which is stupid because they're adjacent to one another and kids are optioning back and forth all the time. But that's the state of the law as it exists now. So this is another piece of homework for you. Go and check your policies and make sure that that tweak got made, because that's a new change that happened last year. And we had one school reach out to us that was kind of getting hammered by a parents advocacy group for reporting everything. And the school had just missed this update to the law. And so they, I mean, it's not the end of the world, but make sure that your stuff is updated so you don't get caught by somebody playing gotcha.
We have a tweet to Chip's question about post-prom breathalyzers with the buses. The parents are calling it a security check, and it's not our buses. Does that change it?
Parents are calling it a security check, and it's not our buses. See, to me, here's the thing. Send home, just tell everybody, here's the game plan for prom. You have to be at the school by 6 o'clock. Doors are locked at 6:30. Post-prom starts at 10, and everybody that's going to get on the bus, the parents are going to blow into a breathalyzer. I mean, that notice is not that hard to give, and then we've met whatever our legal obligations are, we've met them, I think.
Which county attorney do we report to? We have land in 4 counties.
You're supposed to
DO is located.
yeah, you're supposed to confer with all of them, and then the rule, the response from the one where your district office is located is the one that governs. So I know, again, I like Brian. I know what Brian was trying to do here in practice, because Brian said to me, well, we're finally going to get these damn county attorneys, taking an interest. LOL, Brian, they all blew us off. So not all of them. A few of them are really good.
Yeah, a few are very active.
A few of them are really good, but most of them just ignore us.
As in our typical style, we have 1 hour for half the show.
Okay, let's go. So we got badass Bobby here. I need revenge because he now has gotten me in trouble with my mom for having cigarettes. And truth be told, I care less about school than I do that my mom is mad at me. So I say, I know that Bobby has a knife. You, the school administrator, confront Bobby. He is a general education student. We have that in air quotes, and we'll explain here in a second. And he admits, yep, I've got a knife in my locker. It's 6 inches long. You search the locker and you discover the knife is only 2 inches long. But he does have a knife. So now what do you do? I'm going to go through these next few slides pretty quickly. These are the grounds for long-term suspension or expulsion or mandatory reassignment. This stuff, we don't usually like to regurgitate statutes right into policies and handbooks, but this you should cut and paste right out of the statute, 267, right into your student handbook. That's why I'm going to go fast, because it doesn't matter what I say. This is what it is, right? So use of violence, force, coercion, threat, or intimidation. This is threatening to kick somebody's ass. Causing property damage, stealing, repeatedly damaging property or theft, attempting to cause or causing personal injury to a school employee, school volunteer, or any student. And the idea that if it's in self-defense, it does not constitute personal injury. Threatening or intimidating any student for the purpose or with the intent of obtaining money or anything of value. What's kind of interesting here is I've used this a couple of times with people trying to use sextortion. Say, I'm going to show those nudes if you don't have sex with me or keep being my girlfriend. I think that's a thing of value, which on this one right here, I think you get Knowing, possessing, handling, or transmitting any object that is ordinarily or generally considered a weapon. That's what we've got Bobby on, because even a 2-inch knife is considered a weapon. The way you prove what a weapon is you call a cop, and I've had police officers argue that that little tiny razor and those little pencil sharpeners, I had a kid stick that in a pencil eraser, and he was like flailing it around the classroom, and I had a cop show up and actually say that was a weapon, which I kind of laughed at him in my heart, but we got the kid expelled, so who cares? Selling a controlled substance or possessing a controlled substance or alcoholic liquor. We had a girl this year that was caught with a flask of, I believe it was vodka in her locker, and mom's defense was, well, she didn't drink it, so she shouldn't be expelled. It's engaging in possession, selling, dispensing, or use. So it's being drunk on campus or having alcohol on campus. Public indecency is defined in 28806. This is the wrestlers that moon out the bus window on the way home from the wrestling tournament. You got them, as long as they're at least 12 years old and less than 19. And then engaging in bullying, which is an ongoing pattern of physical, verbal, or electronic abuse. That's the definition in 2137. This is the one that I thought when we had the question about assault, I thought it was a sex assault. This one's kind of, I find this one to be curious as a lawyer. Sexually assaulting or attempting to sexually assault if a complaint has been filed by a prosecutor. Notice this does not say being found guilty of sex assault. I had one where the kid was actually acquitted. We expelled him for being charged with first-degree sex assault. He was tried and acquitted, but the school didn't want him on campus because the school thought he actually did it, and we didn't let him back on. The thing that causes him to be able to be expelled is being charged, not what ultimately happens at the end of that criminal case. And notice that this one includes sex assaults or attempted sex assaults which occur off school grounds. The idea here is that you don't want to make a girl sit next to her rapist in English class. And so this is the only one that allows us to do expulsion for conduct that occurs away from school. And then this is the definition of sex assault, which is basically first or second degree, meaning that's engaging in any other activity forbidden by the laws of the state of Nebraska. That's what Bobby's been talking about with the tobacco. The red part here, which activity constitutes a danger to other students or interferes with school purposes. We can always meet that, but know that we have to at least check the box that somehow what they've done interferes with school purposes. And then number 11 is my favorite. It's the one I go to most frequently, a repeated violation of any rules. Now, don't take this literally, but theoretically, subsection 11 would allow us to expel a kid who wears his hat to class 2 days in a row, right? I'm not saying we should do that, but the kid that's repeatedly disrespectful, that flips off the teacher, that just everybody knows is just kind of a badass. When we have them violating school rules, even if those rules did not allow expulsion, if we got them 2 or more times, we got them under subsection 11. So there's the whirlwind tour of all the grounds for long-term suspension and expulsion in the statutes. Some of you have additional things added here, and some of you, that includes tobacco. Understand you can add things, but the statute really doesn't change. So the fact that you've listed it as expellable in your handbook doesn't make it automatically expellable under the student discipline statute. And remember what Steve said at the beginning, the purpose of this statute is to protect students' rights, not to give schools the ability to bounce kids. And so a judge is going to read this list as exclusive, basically. Now, you can add other things because subsection 11 says a repeated violation of any school rules, so you can embroider those down below, but understand anything other than these 11, you're probably not going to get them expelled. In general, an expulsion cannot exceed the remainder of the semester. This is an area when I do bullying presentations for parents, I just take a minute to talk to them about this because parents do not understand. They think expulsion means make that little SOB go away and never come back and bother my kid again. But the Nebraska Unicameral has said we can only expel a kid for the remainder of 1 semester. And as we talk to other school attorneys nationally, we are one of the most limiting states. I mean, we're more limited than California as far as my knowledge goes in terms of protecting the rights of kids to be in school. And so articulating that to parents is helpful because victims' parents think that we're not doing enough and we're doing everything we can. Now, if the misconduct occurs within 10 school days at the end of the semester, you can get the kid for next semester. The reason I'm smiling is there's a big fight among us is the statute says the misconduct occurs. Is that the misconduct, or is that when we discover the misconduct?
It's the misconduct, objectively.
Read the statute.
How aggressive do you want to be? Call me. But no, I mean, the statute does say the misconduct occurs. We've had situations where the school took a calculated risk and we
Talk just briefly about a social media post that is continually accessed at school. I mean, that's the other area where we've gotten a little bit more.
Right. So if we have a social media post that the post itself was made off school grounds, but it's accessed repeatedly on school grounds, the argument is, what is the misconduct, right? If I am checking I've got a mean Instagram account where I say mean things about Bobby's little knife, but I keep checking my likes at school to see if I'm getting traffic on it. My argument is then that is misconduct which occurs on school grounds, and if it occurs within 10 school days at the end of the semester, I can now get bounced for the second semester.
Or aggressor sends it 11 days out, it's checked 8
Victim
days out.
sees
Right.
it, yeah, or the like bullying occurs, the effect on the victim occurs. What is the act of misconduct? We argue that it's both posting and the receipt, both the throwing of the punch and the landing of the punch digitally. We argue that both ends of that are misconduct. You can do 2 semesters if the student causes personal injury to a peer or to a member of the staff. You can do 2 semesters for a weapon, and you can do a calendar. You're required to do a calendar year for a firearm, but then you can back that off. But you're required to start with a calendar year for a firearm because of the way the Gun-Free Schools Act ended up getting implemented in Nebraska. So if you get the kid, if the kid does it, it's May, you're probably out of school May 9th, unless you had a bunch of snow days. So I do something on May 3rd. The question is that within 10 school days? The answer is yes, then I can be bounced for first semester of 2019-20 as well. We do have to do a review over the summer to see if our minds have been changed or if there's any new evidence or new information that makes us change our mind. We do that. I don't think I've ever done the review and then let the kid come back. Because if it's bad enough that you want to expel, usually a review over the summer doesn't change it. But do make yourself a note that if you're going to do that, you do have to review that exclusion over the summer. The review is limited to newly discovered evidence or evidence that changes the student's circumstances. Kid has been diagnosed with mental health issues that we didn't know about. Kid is on his meds now. I'm trying to think what else. There just aren't that many circumstances that would lead me to change my mind. On those sub points underneath that statement, it depends. If the hearing officer is the one that bounced the kid, then the hearing officer does the review. If the family appealed to the board, then the board does the review. Otherwise, the superintendent can readmit the student on his or her own if they've decided that this standard has been met. Personal injury. This is when I hurt a peer or another staff member. If the misconduct is during first semester, we get them for the remainder of the school year. If the misconduct is during second semester, we get them for the rest of second semester and first semester of the following year, and we can always modify or terminate that. A weapon, so this would be Bobby in the scenario we're talking about. You can do expulsion for the knowing and intentional possession, use, or transmission of a dangerous weapon. We can get him for 2 semesters if this happens during first semester, the remainder of the school year. If it happens second semester, if it happened now, we'd get him for this semester and the first semester of 19-20. And notice here that if Bobby's also failing algebra, and normally he'd be allowed to take summer school to get credit recovery, we can keep him out of summer school as well. This is you, right?
It is.
Okay.
All right. This section is not too fun or sexy. So thank goodness we have a question. What kind of services are we required to provide in the expulsions?
That's you, right?
That's what we're going to talk about. This is the pre-expulsion procedures. And so really you have to provide one of 2 things. Either you have to offer the alternative school or you have to follow certain procedures. And frankly, a lot of our smaller schools don't have the alternative school, so we default to the second one. If you do have an alternative school, here's how you do it. It has to include these following things. Not going to go through them. They're there. We can look at those. But the concept I want you to get is either you have an alternative school, follow those rules, or you don't, and then we've got some procedures. We're going to focus on those a little bit more. You do have to have that individualized learning program. Quite frankly, given the behaviors of some of these kids, they don't qualify for special ed. I call these IEP light. I like them. I think they're good for kids. I think it helps them for whatever reason they're not successful in the school environment. I've seen more kids be successful in these alternative programs because it's a more appropriate environment for them, and you can tailor it to their specific needs. So I get that parents are resistant to it, and it sounds horrible to be expelled, and I'm sure it's not a good experience. But I think we have good things that we can provide to kids when, you know, they're in need of that. Take a look at NDE Rule 17. It covers the alternative school. Quite frankly, it just kind of mimics the statute. The procedures for schools without alternative school, I want to focus on this a little bit, just because except for the firearm expulsions, you have to do this before you expel a student. And it kind of is awkward. I don't know if that was intentional or just an oversight, but it makes for an awkward procedure during the timing. So before you expel a student, and we actually put a paragraph about this in our expulsion letter now, so that we say, hey, we're going to have this meeting before this kicks in. But what you have to do, you have to have this conference, and you have to develop a written plan. And so who's included in the meeting? The parent, obviously, the student, the school representative, and this is a minimum. You could have more than this in the meeting if you think it's appropriate. The last one is the one where some of our schools stumble, especially some of our more rural schools. A representative from a community organization with a mission of assisting young people, or a representative of an agency involved with juvenile justice. So we're talking OJS, we're talking HHS, we're talking some of the community programs that you have where they're helping kids and families. And so you need to reach out. I would suggest you have an idea of who that is going to be before you meet them. Because what we found is some schools are scrambling going, we don't have anybody. Who the heck are you talking about? And so it's good to have that lined up, especially when you have those collaborative meetings with the county officials. That'd be a good time to reach out and find out, okay, who can we deal with? Youth pastor, those kinds of things. The plan must specify guidelines and consequences for the behaviors which have been identified as preventing the student from being successful, basically. You have to identify educational objectives that must be achieved so that they can actually continue to get credit, so they can continue to move towards graduation. You can see how it looks like an individual IEP for a non-special ed kid. Specify the financial resources, community programs that are available for the kid and the family. Require them to attend monthly reviews to assess his progress on the plan. You can modify that plan as you go along if you're finding it's not appropriate.
Notice that it says you have to specify the financial resources and community programs, but it doesn't say how much you have to spend. This is where, when Steve says it's an IEP light, he's right, but emphasis on the light.
Yeah, I don't think you're required to provide any financial resources or community programs. You just have to identify. You could. I think you absolutely could. We've got another statute that allows you to spend the money on the kids for educational purposes. So I think you could if you think it's appropriate. The plan must be written, must be adopted by a school administrator, and it must be presented to the student and parent. And so you can see there, so you've got this team. It's kind of, again, like the IEP team. So there's disagreement as to whose opinion is going to carry the weight. What's that plan going to say? You've got the same kind of dynamic sometimes in these meetings. It says adopted by a school administrator. So who's in control of that final plan? It's the school administrator. And that makes sense. It's our plan. If things go wrong and somebody's going to get sued, we want to be getting sued for our own plan, not for somebody else's plan. So again, I think you have to make a legitimate, faithful effort to make it a good plan and then be ready to defend it if it comes to that. So the procedures, long-term suspension or expulsion procedures, same thing. These are the things you have to do. You have to file a written charge and summary of evidence supporting the charge with the superintendent. And this is Bobby's big bugaboo. When you talk about suspension pending expulsion, this is why this is important.
Bobby, he brought a knife to school. I sent him home. Awesome. Sounds good. What authority in the Student Discipline Act did you have to do that? Oh, I just emergency excluded him. And start over. Karen will be driven crazy if you say that. Oh, I just gave him a short-term suspension until we can figure this out. And start over. That's not what you did. A short-term suspension is a disciplinary consequence. If you want to send a student home pending a long-term suspension, mandatory reassignment, or expulsion, the notice from the principal to the superintendent has to include one of two bases in the statute to do that. In the notice documents that we have posted, and if we don't have, we've got several versions of this document. Sometimes you don't suspend the student pending expulsion. Most of the time you do. Rarely do you do this the right way. And that's not a criticism of you. This is a small part of the process statute that is actually several subsections down from the part that says the principal starts expulsion by sending a letter to the superintendent. At the bottom of that statute, it says, if you believe the student is going to be a threat to himself, herself, or others, or cause a disruption to the educational environment, you can suspend them immediately pending the ultimate expulsion. If you send them home and say, I short-term suspended them until we figure out what to do, I emergency excluded them, those are acts of legal significance. You want to send a kid home pending disciplinary action for a long-term suspension or expulsion, it goes in the letter from the principal to the superintendent. Exclamation point.
I think that was the one thing Bobby wanted to talk about today.
See you guys later.
Another question, what if the alternative school has a waiting list? Then I think you have to default to those procedures because you have to provide one or the other. If there's a wait, I mean, if the waiting list is a day, maybe you stall for a day or two. But if we're talking, it's not going to be available anytime soon. You default to those procedures and you're going to have to follow those. Now you could always, when an opening comes up, you could revise that plan and divert to the alternative school, but at least initially you're going to have to go with those procedures. All right, so on the date you make the decision, you're giving that written document to your superintendent. Within 2 school days after the decision, you have to send written notice, either by registered mail, certified mail, or personal delivery to the student and his parent. It has to go to both. We haven't had that raised yet, but we've had schools that generally only do the parents. They have to go to both. And it tells them about all their rights under the Student Discipline Act. It must include the rule or standard of conduct allegedly violated. This is one of the, normally our theory is less is more. This is where more is more. Put in the handbook provision they violated. Put in your policy provision they violated. Put in whatever law they violated. Put them all in. Give them a summary of the evidence. It does, again, a summary of the evidence. It doesn't have to be every single piece, but putting more in is better than putting less in, I think. And so you need to give them a summary of, they need to be able to read that and understand, why am I getting kicked out of school? You have to give them a notice of the recommended penalty and any other penalty which they could be subject to. You have to tell them they have a right to a request a hearing before that penalty goes into effect, unless, of course, they've been suspended pending expulsion, which would be in that letter as well. You have to give them a description of the hearing and appeal procedures. You have to give them a statement of their rights, and they also have the right to inspect all of their student records. They have the right to know the names of the witnesses. So again, you can see that basic due process, right? What's your evidence? Who are your witnesses? That's basic due process. Give them that. And a substance of their testimony, if you know that. And oftentimes you'll just have a student statement or something in there, or a witness statement. And you give them a form to request a hearing.
A statement of their rights, not the actual listing.
Oh, I'm sorry, statement of the rights. But they do have the right to know the names of those people. What do we have here? Oh, the principal. Procedures. They may be, and again, here's what Bobby was talking about. They may be suspended until the date discipline takes effect if no hearing is requested, or if a hearing is requested, the hearing examiner makes the required report to the superintendent. If and only if, and I think we all kind of skip this step, frankly. If the principal determines the student must be suspended immediately to prevent one of these two things, or substantially reduce the risk of interference with the educational function or school purpose, or personal injury to students, other students, or school employees. I don't think that applies to every single suspendable or expellable offense. If the kid has repeatedly broken rules and he's being disrespectful and still is being disrespectful, well, then maybe you need to do it so he doesn't interfere with the educational function. If it was a single explosion and he's really not violent right now, it's just something to think about. This is not automatic. There's some things to look at and consider before you do that. Nothing in the act requires you or precludes you from settling the matter. You can always negotiate throughout this. And you can see our recommendation, start high. It's just like when you go shopping, right? If it's $1,000, you're like, oh, that's crazy. But if it says $2,000 and that's crossed off and it says $1,000, I'm getting a bargain. Look at that, that's fantastic. So always start high, and you can always bargain to lessen it. Because you cannot, once you set it, you can't go up. And we'll talk about that as we go down the chain. But you can always enter into an agreement. You want it to be in writing, but you can always negotiate a settlement of any of these disciplinary matters. So back to Bobby and his big knife. So you have to investigate. Should you call law enforcement? Yeah, I think you have to, because we have a violation of the criminal code. So I think we need to do that. You have the grounds to expel or long-term suspend, because we have the weapon. Determining the length of the expulsion. These are a lot of calls we get. Okay, I'm going to do this. How long do I kick him out? What do other schools do? We get that quite a bit. And so I enjoy having those conversations. It's fascinating to me to see how you guys determine what's appropriate. And there is a difference from school to school and from regions of the state. So it's fun to have those discussions. Prepare those alternative school arrangements, especially if you're going to follow the procedures as opposed to having that alternative school. You got to get that lined up. I mean, you can see you've got a list of people that are required to be there. And again, you may want to have additional people there as well. So you have to make sure they're available in a very quick, like that day or the next day kind of thing. Give that written charge and summary to the superintendent. Send or deliver that written notice to the parents within 2 days. So we give it to Don and Brenda and let them know we're going to expel. Include all that required information we talked about. Decide again if the student is suspended until the discipline takes effect. This is what we got a knife, right? Maybe he's going to keep bringing weapons. This would be one where, this might be something where we're afraid of personal injury or he's going to interfere with that educational function or school purpose. And then, of course, throughout, but usually it's at this point where settlement discussions get serious and they actually talk about, okay, what can we do? That it starts to sink in. Yeah, my kid's getting expelled. Okay, what does that mean exactly? What can we do? Can we bargain here? Can we bargain a little bit?
One question that was texted and that Steve kind of hit lightly, but I wanted to circle back to is what services do we owe Bobby now while he's expelled? If we don't offer an alternative school and we have that meeting that Steve talked about, and there's a sample, there's a blank plan on the website. There's also a sample one that we filled out just so you could kind of see what we would put in the blank sometimes. But once we do that, we don't owe Bobby, we owe him some level of educational service, but it's not very damn much. If you don't think Bobby's going to do anything, I don't think there's any reason for you to pay for Odyssey Wear for all 8 of his required classes, for example. I'd probably get him set up with one and say once he is successful in completing his English, then we'll set him up with social studies or whatever his other requirements are. If you already have like a full subscription to that learning software and you can give Bobby access without a huge expense, I'm tempted to give him that expense or give him that access. And then the other thing I love about an online option is that you can track how much time he spends on it so you can see if he's working at it or not. We have other schools that have the kid come to the library for an hour a week. We have some schools that have like migrant packets that are like paper that they give to the kid who's expelled. So it doesn't have to be very much services for a student who is a gen ed student.
You got to check in monthly, though. That's the thing that we see dropped
yeah.
off pretty often.
Yeah.
All right, we have a question. Do I have to write a letter to myself if I do both jobs? That's from Shane Alexander. Great question. We have a lot of those superintendent / high school principal. As weird as it seems, yes, generally what we do, we prepare a memo to the file because you're not going to send it from Shane principal to Shane superintendent. So we just do a memo to the file and have that document. That's
also the document that you need to use to send them home right away. So we can't skip it. There's no other place to do it. It's as foolish as it seems. That's a place to do it.
Do you have a recommended list of law infractions to report to the county attorney? I envision our county attorney having no idea what he would or would not like to have reported. We do have a default provision. If you're a policy subscriber, we have a default provision in there so that it covers it just in case your county attorney doesn't respond.
We do not have a list. What we have said in our policy is we will report those things, for example, number 1, that pose an ongoing threat to other students. Number 2, that we don't believe can be appropriately addressed by traditional student discipline. So it's a little bit unique. We don't have a list per se.
But we have something that hits that.
But it kind of gives you guidelines about what, and you can interpret those and
If they're not
report.
service subscribers.
What is the procedure if you send notice by certified mail and the parents refuse the letter? Great question. We don't have the answer in the school context, but we do in other contexts. All we have to do is send it. We don't have to see that they received it, as weird as that is. But as long as you send it by certified mail, your obligation is done.
I always say hand deliver it, email it, because of that statute Steve talked about that said actual notice is what we're after, right? But you have the option to certified mail it. If they don't want to pick it up, sorry, right? Then their 5 days goes by and they don't request a hearing. Keep sending questions in. We have 34 minutes to cover a lot of content, so I'm going to go quickly through firearm expulsions. These are the ones that Karen talked about. These are mandatory for 1 year. So Steve returns from his yearly vacation to Detroit. drives his truck to school. Cody parks next to Steve and sees his bevy of weapons in the back, including firearms. The snitch, who I'm assuming is Cody here, reports to the principal that Steve has at least one gun on school grounds. Firearm expulsions are specifically covered by the Student Discipline Act. It's a kind of a fall down into our statutes from federal law. And even though that federal law has changed, our state law has not changed. Under Nebraska law, you must have a policy which requires a minimum 1-year expulsion for firearms, period. So expulsion for knowing and intentional possession, use, or transmission of a firearm has to be for a period of 1 calendar year, not 2 semesters, 1 calendar year, all 365 days starting the day after the offense occurs. It does not apply to, and there are certain exceptions for things like ROTC training, hunter safety, firearms which may be possessed by a person receiving instruction. So there are a few exceptions. But if you're talking about the traditional circumstance, kid goes hunting in the morning, drives to school and parks on your in your parking lot, which is on school grounds, with the shotgun in the back or the rifle in the back, that is a mandatory 1 calendar year expulsion. Now we'll talk about what all of you jump to immediately, which is, can we shorten that? But your policy must say, you bring a firearm on school grounds, you're out for a calendar year. So the policy must actually say that. So any student who is knowingly or intentionally possessing, using, or transmitting the firearm on school grounds, in a school vehicle, at a school activity, is out for a calendar year, period. That must include a provision authorizing either the superintendent, and it should say and or the board, to modify that expulsion on an individual basis. So Steve, who you believe may have bad intentions with that gun, you can say, no, Steve, I'm sorry, that's a calendar year. Although Steve gets the same due process rights and a hearing as he would if under a traditional expulsion, you can say to Steve, we're not going to shorten it. We recommend that your policy allow the superintendent and not require board approval to shorten that, because what happens often in these cases where a student's been hunting is he totally just forgot to drop it home, or he was running late, or she forgot that it was in there and brought it to school. We'd have no safety or security threat. Okay, maybe we shorten that to a 1-day out of school suspension, or even something less in theory. But you cannot avoid the process of implementing a 1-year expulsion and then shortening it. So the statute contemplates you're going to shorten it fairly often, right? That actually also has to be in the policy. You must annually report these to NDE to provide an assurance, number one, that you have the policy in place, description of the circumstances surrounding any firearm expulsion. So Steve brought it from Detroit. Karen was out hunting in the morning and had it. We have to describe to them why it is that we impose the expulsion, the name of the school, the number of students that were expelled, and the types of weapons that were concerned. Those are the reports, and I'm sure we're not telling you anything you don't know. What is a firearm? And this becomes important. We don't actually have a definition in state law. It's from federal law that we get the definition, and frankly, they tend to change that around by regulation in some cases. But the current understanding from federal law is any weapon, including a starter gun, which will or is designed to readily or be converted to expel a projectile by the action of an explosive. So this is not a BB gun, but this could absolutely be any other handgun, shotgun, rifle, whatever it might be. The frame or receiver of any such weapon, right? So you don't have to be actively able to fire it for it to constitute a firearm. That's a question we get fairly often. Any firearm muffler or firearm silencer. So if all the student has in his or her vehicle is a silencer, that is a mandatory 1-year out, which can be shortened. Any destructive device, which is some sort of bomb. I mean, it's a lot of things. So the definition is probably a little broader than you're thinking about. But the term does not include something like an antique firearm. And again, doesn't generally include BB guns, air guns, paintball guns, airsoft guns, that sort of stuff. Am I missing anything? Okay. So back to Steve. We've got to send and deliver the written notice to students and the parents within 2 days. This includes the letter from the principal to the superintendent first, which says we're going to keep Steve out during the pendency of this expulsion. Decide if the superintendent or board is going to modify the expulsion. You should know in your policy what that says, because if it says board, that may mean a special board meeting before you can bring that student back, or you're going to have to wait a month, right? If it requires board action, our policy says superintendent for that reason, superintendent or board. Decide if the student is suspended until the discipline takes effect. That's one we just talked about. And again, you can say to the family, hey, Steve, you know you can't have the gun. We'll enter into this, basically this agreement, this expulsion agreement, we call it, which says you promise that every morning, you'll make sure and check that you don't have the gun before you come here, and we'll let you come back in 2 days or a day or something like that. So the principal or other school official must take immediate steps to notify parent or guardian or a responsible relative if, in the event Steve brings the gun to school We notify law enforcement. They agree he was going to use it for bad purposes. And so the police actually come and arrest Steve, right, for possession of that gun on school grounds. That's a felony in the state of Nebraska. Steve could be charged with the crime in addition to our 1-year expulsion. So if that happens, we have to notify the parent, guardian, or some responsible relative that Steve's been arrested at school. The exception, obviously, is for child abuse and neglect. We just noted up here because I think all of you are generally familiar with that. But it's the same statute that talks about the child abuse and neglect stuff that also articulates the requirement to notify parents if students are arrested at school. Okay, so we've talked about these throughout. Basically, our thinking on this document that we call an expulsion agreement is essentially this. You can institute student discipline, there's no doubt. If you've got all the boxes checked, you can do it. You can go through a hearing. They can appeal that to your board. They can appeal that up to a district court. They can get all the way to the Nebraska Supreme Court on the question of whether you can expel a student. What is obviously in the interest of the district in a lot of these cases is to avoid having to go to a hearing and the expense and sort of heartache administratively and the time that comes with that. So we think you can enter into, and the Student Discipline Act says, that, hey, we'll sign an agreement with you, family, that says your kid brought a firearm on school grounds. We could expel him or her in exchange for, number one, a good history of the student. We don't believe he or she was actually a threat. Any of these things that we can put into an actual agreement with the family that says, here's what you're going to do as a condition of being able to come back early. So an expulsion agreement could be used outside of the firearm context as well, but we use it in the firearm context pretty often because we think it's an easy way to articulate your logic for why you brought Karen back when she would just accidentally forgot the gun because she was hunting as compared to Steve, right? Some way to articulate why we handled those differently. An expulsion agreement is a good way to do that. At the conclusion of the suspension period, the school must, number one, have a satisfactory performance on plan or other, getting a message here.
Talk about ammunition.
It can if it's a destructive device, right? That's
Yeah,
pretty much where we get to. Yeah, good question. If you're talking, depends on the type of ammunition. It could constitute a destructive device. I think it was Robbie that sent that. It's really going to depend on what type of ammunition you're talking about. And what it is that if it's going to be expelled by way of explosive, is the ammunition in and of itself a destructive device. The statute and the definition or regulations of firearm don't specifically say just ammunition, but I think that's right, that it could be a destructive device. And again, these are all things you can put in expulsion agreements. I'm sure we would be happy to show you an example of that if you're thinking of using one, help you put one together. And if the student is reinstated, the district may also expunge the record of the expulsion action. Now, you still have to report to NDE and do all of that stuff, but it is possible to handle these in these expulsion agreements.
Sorry,
We're trying to go quickly. So.
I'm looking for the starter pistol answer to the question.
Yeah,
About
we
whether or
got
not
a
to
question that
get
says starter pistols are a mandatory ban for students. Is it okay for our track coach or PE teacher to have a starter pistol in his file cabinet?
And I'm working from memory, and I was trying to quick search the drive on my phone and didn't get it done. My memory is that starter pistols don't expel a projectile by means of an explosive device. So I think it maybe depends on the kind of starter pistol. I knew the answer to this at one point in my life. I don't know it standing here for sure.
Call your county attorney, because the possession of a firearm on school grounds is a felony. And if they say, oh, a starter pistol wouldn't count, right? Then our Student Discipline Act applies to students, not right. to your
That's
coach.
Right.
So if your county attorney or your law enforcement say, no, a starter pistol isn't a firearm, and we're never going to charge you for that, you'd be to some extent relying on their legal advice in that case, but at least you know. That's the question.
Yeah.
Because I think it could be.
Yeah, it depends on the different kinds of starting pistols, as I recall.
Yep.
Going back to the following the procedures for an alternative education, what happens when students refuse to follow their education plan? Can you make it a requirement for them to return? No.
Oh, don't you wish?
I wish we could. They can sit on their butts and not do a darn thing and do nothing on that plan. When their 6 months is up or 3 months or a year is up, they get to come back.
They don't get to come back with their same age cadre if they haven't mastered the curriculum. But all that means is you get another lovely year of them in your high school. So most of the time, we're pretty eager to keep that kid moving along academically. Okay, so Steve is expelled. And he's running around the house with his guns and his chaps yelling, I'm a cowboy. And then Steve's parents say, oh, good news. We had optioned him into this district that expelled him. We can make the resident school district take him. So they notify their resident district, they're canceling Steve's option. He'll be in school on Monday. Can't wait to see him. Do you have to let him in? You all said no in your heads, and that answer is correct. Students who've been expelled from a public, private, denominational, or a parochial school, even if it's not from Nebraska, if they haven't completed the terms of the expulsion, they can't enroll in any public school until, look here, the school board has to approve the enrollment. This is not one where we want the board to delegate the authority to allow that to the superintendent, because the board is going to be under tremendous pressure most of the time to say no, because we don't want more discipline problems in our schools. And so we want the board to be able to say no. And it also gives us a nice long lead time, because usually there's not a board meeting immediately when Steve's parents call and say they want to enroll him. And so what we tell superintendents and principals to say is that would take board action. I can tell you our board has never allowed it, but if you want to request it, I can put it on the next regular board meeting agenda. But I'm sure I can predict pretty confidently they're going to say no. You can only keep a kid out who's been expelled from a private denomination or parochial school if that expulsion was something they could have been expelled for at a public school. So if Steve is standing up during mass yelling, "Mary wasn't a virgin, we all know she was a slut," probably not going to be expellable in a public school, but definitely expellable from a Catholic school. So he may be able to come back to public school for those circumstances. The board then can also say, like if the family's moved in, Steve moved in from Detroit, he was under expulsion in Detroit, now he's moved into York, and he wants to go to school in York, and York, I happen to know, runs an alternative school. They could the board could take action to allow him to enroll and require him to serve out his expulsion at the alternative school. But again, we always tell the board to say no. I just told you this. You can't keep him out of his resident district for longer than the expulsion, which was original. So the calendar year for the guns, you can't keep him out of the resident district for more than a year. And then the second thing, for a public school student, that's the Virgin Mary exception. You have a question?
We have a question. How do you handle adults who have a firearm in a vehicle? Does an adult with a concealed carry have the ability to have a firearm in their vehicle?
You know this is the best.
Yes, they can. If they have a concealed carry permit, they have to lock it in their vehicle. They have to put it in a lockbox and that kind of thing. And so, yes, they could, as long as they follow those proper procedures. But essentially, it has to be locked up in a safe place.
What's interesting is my husband has a concealed carry permit, and they told him in the class that he had to take that there were no grounds on which he could have a gun in school grounds. And then Steve's like, "No, you can't." And then he shows them all the ways that you could have a gun on campus. So it has to be in a locked thing with the ammunition stored separately and basically make it not useful to you. But if you
Right.
follow all those steps and you have a concealed carry permit, you can have it out in school.
And we'll be talking about that on Friday at NERCSA, about arming teachers and all of the exceptions. So anyway, all right, hearing requests. If a hearing is requested within 5 days of the hearing or of the decision to expel or do a long-term suspension, the superintendent appoints a hearing examiner. Within 2 days after that, they have to give written notice to the principal, the student, the parents, and at the time of the place of the hearing. You can see these are pretty quick. This thing moves very quickly. The hearing examiner, who is it? Currently, the law is it can be anybody designated by the superintendent, as long as they're not biased. They didn't bring the charges. They weren't a witness. They have no involvement in the charge. So it could be anybody. Oftentimes, what we see is you call your neighbor, superintendent, say, "Hey, will you come? If you'll come do this one for me, I'll do the next one for you." We also have many retired administrators who will come in and do it. They do a fantastic job. They go through training to be a hearing officer and do it. The Vargas bill, I think it's the 515. That's one of the ones. This might change. A parent will have a right to object to whoever you appoint. Then you have to have this list of 5, and essentially you're going to cross one off, taking turns, and the last one standing is going to be your hearing officer. So we'll see if that goes forward.
There's an amendment that says just one now.
Oh, very good. Okay, so they've amended it. It would just be one person. So that'd be helpful. It does not have to be an attorney or educator. It typically, in our experience, has been a current or former educator. I've never had one where an attorney sat.
I had a retired.
Oh, we had a retired board member do. Okay. All of mine have been superintendents, current or retired. The hearing must be scheduled within 5 days after receiving the request, unless the hearing examiner finds good cause. Oftentimes, they'll consult with legal counsel to determine if there's good cause, but a lot of times the parents will actually request that be continued, and we're happy to do that. You cannot hold a hearing without 2-day school notice to everybody unless everyone agrees to that. And again, oftentimes parents are interested in agreeing to do that because they want to get this issue addressed. Examination of records. Everybody gets to look at the records. Records, written statements, statements of any witness at a reasonable time prior to the hearing. There's a question about what a reasonable time is. Quite frankly, this goes so quickly. Thank God for email. That's changed things. We've typically been able to email this stuff to parents as soon as it's available. Other times in late 90s or so, this would be hand delivered right before the hearing because that's when it was put together. So, and that's when they would see the parents. If there's no hearing request within 5 days, the punishment goes into effect.
We're talking about they didn't pick up the certified letter.
Oh, if they didn't pick up the certified letter,
Suspended pending expulsion.
yeah, they're suspended pending expulsion, and they haven't requested a hearing, it's going to go forward. I mean, that's, again, if they don't want to pick it up, that's fine. It doesn't hamper us. It's only going to hurt them in exercising their rights. If they have a hearing request in 30 days, so it's more than those 5 days, but less than 30 calendar days, you still have to hold a hearing. So really, we've had a few of these over the years. It would obviously be an expulsion or a very long-term suspension, but typically it's an expulsion. They said they didn't want a hearing, they changed their mind. But that recommended punishment goes into effect pending that final determination. Appeal rights, very quickly. We intentionally didn't put this in here. Principals don't need to know this at this point, and we knew how long this was going to go. You get to appeal to the board. It's on the record, which essentially means it's based on the evidence that was presented below. So all that's recorded and typed up and all that stuff. They do have an exception if there was some reason they couldn't produce it below. They could do it. But really, this is supposed to be on the record. It's not supposed to be a second hearing.
How many appeals?
How many appeals have I had? 3? Karen's had 2.
So it doesn't.
And I would say the ones that I've had that were appealed were not the cases I would have appealed. But basically, you have unreasonable parents in most of those cases. Just unrealistic parents. They then can appeal to this district court, appeal up to the Court of Appeals or Supreme Court. So we have. Oh, what about ammunition? What if a student has ammunition in his or her car? Again, it's going to depend on what kind of ammunition. Is it one of those explosive devices?
Okay, so we've got 15 minutes left, and I'm sure everybody there is, on your end is probably, if you're watching at school or in a unit, ready to be done. We get that. What we have for the balance of this presentation is 2 topics that we want to get to, but a small caveat. Number 1, we've got students with disabilities, whether that be on an IEP or a 504 plan. And then we've got Title IX, a discussion about how those things line up. We have talked about Title IX. If you're interested in more of that, we've got that webinar and all that stuff recorded. Let one of us or Sherry know. And the discipline of students with disability stuff, we're going to try to hit as much as we can in the next 15 minutes. We're going to, I think, probably only get to a fairly big guidance letter that came out from the feds on these students who are not yet verified, but you've really been suspecting that they might have a disability. That's probably all the further we get. So I'm going to go quickly through this. The reason I lead with this and waste our precious time here is our plan after doing these webinars this year is to ask all of you what you want for next year when we kind of roll out our webinar plan. One of the things we've heard a lot of feedback on is we want more special education stuff, and in particular, special education students and students with disabilities, the extent to which discipline and placement and all that stuff overlaps. Steve.
Have them text their ideas.
Oh yeah, there you go. And if you have any ideas now for things you want to hear, text those to Steve. Any webinar topics that we should hit on. But just so you know, we might not get to everything that's left. I am confident we will have to do another Title IX webinar fairly soon whenever the feds finalize those new regs. And we're going to focus on some special education and 504 issues for next year. So again, if you've got specific questions about students with disabilities being disciplined, send those to Steve. If you have topic ideas, send those to Steve. If you are intent on getting out right now, understand we'll cover this stuff in the next few months, hopefully at the beginning of the school year. But for the next 15 minutes, we're going to breeze through as much of this as we can. What are the legal options for dealing with students that have disabilities? We start here at a baseline level because too many administrators still just jump to traditional discipline. So you have traditional discipline options. All of you sitting there are thinking words like manifestation determination, behavior intervention plan, functional behavior assessment. That's good, right? The right bells are going off in your head. But one of the things that we challenge you to do, and we talk about when we get these calls, is to talk about traditional discipline as an option, but also think about whether the data that we've now gathered, this misconduct is data. At the end of the day, that's what it is. So if it's a series of things that lead you to believe we need to expel the student even if he or she's on an IEP, let's think of those as data in addition to student discipline, traditional discipline, because you could do things like get the team together and decide maybe the student's placement is inappropriate. You could review the behavior intervention plan they have in place, put different educational strategies in place, and you might have to look again at verification options, right? If this has traditionally been a student that receives speech language services, but you've now got a whole history over the course of the last year of this student really acting out behaviorally, you may have an obligation, a child find obligation to decide, does that student qualify for a student with an emotional disturbance? Are they just socially maladjusted? Are there other socialization services or related services we have to provide? So I would challenge you to stop thinking about it in terms of, well, a traditionally disciplinable event happened, we must traditionally discipline. Think of the other tools that you've got available to if it's a student with disabilities. So generally speaking, students on an IEP, they engage in misconduct. The school may remove a child with a disability from his or her current placement for a period of time not to exceed 10 consecutive school days. These are the 10 fate-free days or 10 days that you have before you have to hold manifestation that everybody's generally familiar with. This part of it is where it gets interesting, especially for these students with repeat behaviors. If you have a series of removals that add up to 10 days for the same or similar misconduct in the same school year, right? We restart our 10-day clock every school year. That's a question we get pretty often. Second semester this year, we had 8 days out. First week of school next year, we want to do a 3-day out-of-school suspension. Bobby, are we at day 11? No, you're not. You're at day 3, right? It restarts every year. But the concept of aggregating these things happens over a school year. So if it's the same or similar misconduct, you might have to aggregate those together for purposes of counting to 10.
That it follows the kid, he's transferred or option.
Those removals follow the student. So in the example we talked about, Steve, where we cancel the option over here and try to go back to our resident school, those days that Steve's been excluded, right, by his original LEA are going to follow him to his second LEA for purposes of counting to 10. So you're going to have to get the records. And in some cases where we've seen, you got to piece together what that school did. And if it's, we gave Steve 2 days of ISS and all we did is call the parents, you may have maybe a note somewhere in Power School. You've now got to be able to look through all that and know how far you are into your counting to 10 if you get a student that comes in mid-year. Okay. So always count out of school suspensions. Anytime a student is removed from his or her actual physical placement where that student receives services, typically speaking, if that's out of school, you're going to count it. Sometimes you may have to count in-school suspensions, bus suspensions if transportation is a related service in their IEP, and portions of a school day, even if it's not an automatic out of school. If it's something like an in-school suspension for half a day, you may have to count that. Rarely do you have to count things like after school detention or lunch detention. The reason that we kind of focus on ISS is because we get this a lot. Oh, don't worry, their placement wasn't changed. We're not counting to 10 if it's ISS. More and more, as I read the cases, I just think, go down to number 3 on this list. The student continues to participate with non-disabled children to the extent he would have in his current IEP placement. If that kid's IEP says you have nothing more than pull-out services, but you're otherwise in the gen ed classroom, if that kid's not in the gen ed classroom at any point that day, they're not participating with non-disabled children. So that day of ISS counts. So this concept of we'll use ISS to avoid counting to the 10 days, I just don't think we're sort of losing some of the power on that. And frankly, it's probably because some schools have abused it to the extent we look at it. It's a change of placement, right? That's what we're looking at.
There are also an increasing number of cases nationally that look at sub 3 there and say that if Bobby is taken off the school bus, even if he's not receiving busing pursuant to his IEP, but everybody in the district gets to ride the bus because we're one of those nice districts, then he's not, think about if you were a bus kid, think about all the stuff you learned, whether it was good or bad, on the bus by hanging on the bus with your peers. That bus removal is, I'm starting to count bus removals towards a 10, whether it's in his IEP or not. Because it's better to get to 10 sooner and be prepared than it is to get caught flat-footed.
Okay, so the manifestation determination, you have to ask, really it's 3 questions, right? But here's what I'm talking about to set Karen up to end this thing on what we call the secret 4th question. Was the misbehavior caused by the student's disability? If the answer is yes, that's a manifestation. Was the conduct caused by, or did it have a direct and substantial relationship to the student's disability, right? So caused by, related to, those are the first 2 questions. The third one, and the one that we don't see asked often enough, was the misconduct a result of the district's failure to implement the IEP? failure to render the services that were discussed in the IEP. And sometimes that can be the student, right? You're working with a student who has attendance issues. Those raise interesting questions about whose responsibility it is to make sure those services were rendered. Should you have gotten the team together to talk about attendance? And then if the student went for 3 weeks without being served because there were these attendance issues, whose fault is that, right? So there's a lot of sort of sub-questions within these 3 questions, but those are the main 3. We talk about this as the secret 4th question, even though it's not really a secret. It's in Rule 51, it's in the federal regulations, it's in the IDEA itself. If a general education student should have been verified, if the district had a basis of knowledge to think that that student may have a disability for which he or she could be verified under the IDEA, that student may be entitled to what we call pre-verification processes, including manifestation, which I'll let Karen hit on because it gets a little bit weird to think about that. But the secret 4th question that we always say is the student on an IEP? Well, no, Bobby, of course not. Should he be? Should she be? What data do you have that suggests maybe this isn't an isolated event? That's a question that we now are having to ask. And the feds are obviously getting questions on it too because they just put out guidance on that issue. If it is not a manifestation, you may discipline the student just like regular education students. You still have to put a plan in place for the student to be educated through your IEP team, but you can move forward with traditional discipline. This would sort of be combined with those pre-expulsion procedures that Steve talked about, where you have to have a plan for the kid. I think your IEP team becomes a team that puts that in place. If the conduct is a manifestation, you cannot discipline. If you haven't done one, you must conduct a functional behavior analysis or assessment, implement a behavior plan and or change those or do another one if you've already done them. And you have to return the student to the prior placement unless you and the parents agree, okay, maybe we can change it. But if it's a manifestation, you're basically locked into those options. And that's why we say, rather than launching this discipline concept, immediately make it about the services to the student. And you're probably going to get a more permanent solution to that issue than you'd get by really chasing what can sometimes be a bit of a ghost in terms of traditional discipline. Regardless, consider the benefits of changing the placement versus discipline. That's kind of what we're talking about. I'm going to just cover this briefly. You know that there are weird rules that apply to weapons, guns, drugs, and those sorts of things. Serious bodily injury is another one of those. In the event you have one of these things, a student has a weapon on school grounds, that's where you get the length of the knife mattering compared to the Student Discipline Act. But they've got illegal drugs or they cause serious bodily injury, which is pretty much like a lot of blood and exposed bones, or it doesn't really count. If one of those 3 things happens, you can get 45 days under the IDEA, even if it's a manifestation, right? So the student has inclined to impulsivity, and that student says, well, that's obviously why I brought this gun to school. I wasn't even thinking about it. You could say that's a manifestation, but you're still going to be out for 45 days. Again, that doesn't exempt you from following our student discipline processes. That's number 1. And number 2, a lot of time you actually cut the work down by about half to decide if that's a placement issue as compared to a discipline issue. Here we go.
Okay, so would you check and see if that chat is the same chat? So we put this deck together knowing we weren't going to get through all the special ed stuff, but the special ed stuff is so crucial to the questions that we get. We really felt like we had to give it to you. So as you look at the child find stuff and the other things that come after this, we want that as a resource, and I really think we need to do a standalone webinar just on special ed discipline. But I wanted to take a minute to talk about this letter to Nathaniel. We have a copy of it up on the website along with the other materials. Here's the question. Steve is a constant pain in the butt in class. He can't leave his peers alone, can't keep his hands to himself, doesn't do work, hugely distractible, shows up to school with a knife, and the blade of the knife is only 1 inch long. And we want to do something to Steve because he brought this knife to school. So you call and I say, is he special ed? No. And then I say, should he be? And the principal says, well, I don't know. Yeah, he's really smart. If his parents would just give him his Ritalin, he'd be fine. Or if his parents would just take him to the doctor, we told the parents that he should go see and get diagnosed with ADHD. Dude, at that point, you have to treat Steve as if he had an IEP, even if he doesn't have one. And this letter says that you have to do manifestation for Steve even before you know what his disability is. So you notice Steve up for possible expulsion. In the same letter, you say, please consent to let us test him. And then while that testing has happened, you've got 45 days to get that testing done. But in those 10 days before he's bounced for the 10th day, you still have to get a group together to do a manifestation determination. And then what you're talking about is basically a hypothetical disability. That's what this letter to Nathaniel says. You have to talk about the data that you have and say, well, assuming Steve does have ADHD, could bringing the knife to school have been a manifestation of his disability? Well, he's got impulsivity if he's got ADHD. Was this an impulsive act? And what this letter says is that's what you have to do even if he does not yet have an IEP. What are you doing? Yeah. So if a child who has not been determined to be eligible for special ed has engaged in behavior, you have to treat him as if he was a child with a disability. This is straight out of subsection 16 of Rule 51. If he's violated, what do you want me to say? Come say it.
Well, I didn't know what you were going to say. I'm trying to get to this part that talks about when you have knowledge.
Yeah.
Because it's not your choice all the time.
Right.
Your
If a
teacher's
parent
thing.
has said in parent-teacher conferences or sent an email to the principal saying, this is not fair, my kid can't pay attention. Everybody knows he has. We have a bunch of parents saying now he has ADHD and they've never taken him to the doctor. But once a parent says that, your obligation to deal with that request is triggered one way or the other. The parent has requested an evaluation, and understand that doesn't have to be a please evaluate my child pursuant to section 34 CFR, section 300, whatever. It can be, I want my kid tested, that's enough. And this is the one I worry about. Teachers or other personnel have expressed specific concerns about the behavior. Oh yeah, we satted Steve because he was so obnoxious. The teachers talked about it all the time. You've triggered your obligation to treat him as if he was special ed, even if you haven't tested him yet.
So if your teachers are sitting at lunch with your special education coordinator and say things like, we really have to do something about Steve. He has been disrupting my class for a year now. I don't understand it. It sure seems like he's got to be one of these kids with a disability, right? That discussion, even if your principal's not sitting there, if it's your sped director, if you're a special education coordinator sitting out there, you got to know that you now might have to put the brakes on your administrators from traditional discipline.
And there are administrators who've gotten the wrong impression from, I think maybe it was a school law class that you took when you got your administrative endorsement. Somehow we don't want to verify the kid as ED because that's bad, then we can't punish him. Dude, if you're talking about his behavior, he's getting an ED verification on the cheap. It's better to actually have tested him and say yes or no.
One of the reasons we bring this up is you should not be afraid. In fact, there are only two responses, right? If a parent says, please evaluate, yes, ma'am, and no, we're not going to, here's your notice of here's your prior written notice.
Yep.
You have no knowledge. So in other words, if you say to mom, we do have a lot of concerns about Steve. We would love to test him to see if he verifies for services under special education. And mom says no, and that box is checked. Now you can sign that. Now you can discipline Steve, even if you know to your core he's a student that has emotional disturbance.
Yep.
If you have knowledge, it's best to address it. That's where we're getting.
Yes.
Okay.
Yes. Okay, 12 o'clock. So text your final questions to us here. We will, those of you that are jumping off right at noon because you got lunch duty or whatever, thank you. We will have the recording up, and just like in the past, we're going to put it in one big chunk and then in each subtopic. Again, let us know if that is useful to you or if that's a pain to you, or we really want to make sure that this recording stuff is useful to you. But I'm thinking that, listening to a 10-minute section on long-term suspension, that when that's what you're thinking about doing, is better than having to sit through a whole 3-hour webinar. And then text Steve-O if you have topics that you want us to talk about for sure next year. And we're also going to do some sort of solicitation of everybody to have you give us a chance to give us some topics and ideas.
One more question. If the parents don't supply or refuse to supply meds, are we still at fault?
If the parents don't supply or refuse to supply meds, are we still at fault? You're not at fault, but the IEP team needs to put together a plan for how are we going to deal with unmedicated Steve. In fact, I have a few schools that have a protocol in the morning and we've written it into the IEP. Steve, did mommy give you your pills this morning? No? Okay, you're going with Mr. Truey to the resource room because we know it's going to be a bad day. Did mommy give you your pills today? Yes? Then come on into Mrs. Hazi's kindergarten classroom and we will serve you there. And that's not punishing, that is dealing with an unmedicated child. But you can't make attendance conditional on taking the meds. The last thing, if you have a family that doesn't consistently medicate, my go-to response is to offer to medicate him for them. So, hey mom, if you send us the prescription, we'll give him the pill every morning at 8 a.m. Because a lot of times also the timing of meds matters, and you can tell when a kid hasn't had them consistently. So if we can supply that medication protocol, and then Mondays and Fridays, or Mondays are going to be a little bit of an adventure because he may not have it over the weekend, we can run a different plan for Mondays than for the rest of the week. So that there's things you can do to address the lack of medication, but when you say at fault, he's still a special ed kid and you still have to deal with it. All right, you guys have been awesome. Thank you so much. And we will see many of you at NERCSA, and the rest of you, we will see you when we see you. Bye.